Good morning, everyone. Good morning, Advocate Maema.
Good morning, Chairperson.
Good morning, Advocate Chauke. Advocate Gauteng, I believe that you have ended your evidence in chief with Advocate Maema.
Indeed, Madam Chair, I've got no further questions.
You've got no further. Advocate Mtsweni.
Good morning, Madam Chair and members of the panel.
To proceed, sir. Advocate Maema, you are still under oath.
That is correct, Chair.
Proceed, Advocate Mtsweni.
Thank you, Madam Chair. Advocate Maema, I just want us to clarify a few aspects arising from your evidence. And I think in order to contextualize my questions, I would like us to start by looking at the legal framework that governs the NPA. And I think before you should have a document, a bundle marked LG.
Oh, yes, I do.
I will ask you to turn to LG 183. That is where you would find the NPA Act. (183).
I am there, Chairperson.
Okay, thank you, Madam Chair. I think I'm not going to bore you with the standard quotation of Section 179. I think everyone else in this room understands what Section 179 entails. It establishes a single prosecuting authority. What I want to go into is the composition of that prosecuting authority. And the first one is Section 3 of the NPA Act. Do you see that?
I can see that,
And
Chairperson.
I'm not going to ask you to read it for the sake of time, but what the gist of it is that it provides for the structure of the single prosecuting authority by saying that it comprises of the Office of the National Director and the Offices of the Prosecuting Director at the High Courts established by Section 6.1. Do you confirm that?
I confirm that, Chairperson.
Yes. And then Section 4 provides for the composition, basically the hierarchy of the prosecuting authority. It says it comprises one of the National Director, Deputy National Directors, Deputy Directors, and Prosecutors. Do you confirm that?
I confirm that, Chairperson.
Yes. Madam Chair, if I'm too fast, please do tell me.
We'll let you know if you are.
Yes.
Yes, thank you.
And then Section 6, you would recall that in Section 3B, there were offices established in terms of Section 6.
DPP offices, yes.
Yes. And it provides that the minister, basically the cabinet minister responsible for administration of justice, must establish an office for the prosecuting authority at the seat of each division of the High Court, provided for in terms of Section 6.1. Do you confirm that?
I confirm that, Chairperson.
And then Section 6 sub 2 provides for the establishment that an office established in terms of the section shall consist one or the head of the office who shall either be a director who shall either be a director or a deputy director and who shall control the office. Do you confirm that?
I confirm that, Chairperson.
Basically meaning that each office of the DPP is headed by the DPP
That
or
is
a
correct.
deputy director.
Yeah.
And then below him or her, you would find deputy directors, prosecutors, and persons contemplated in Section 38(1). Those would be your Section 38 prosecutors.
That is correct.
And then the administrative staff.
That is correct, Chairperson.
Yes. Now, I want us to look at Section 13. Which provides for the appointment of directors, that will be the DPPs.
That is correct, Chairperson.
And Section 13(1)(a) provides that the President may, after consultation, I'm just paraphrasing, I'm not quoting verbatim, may, after consultation with the Minister and the National Director, subject to subsection 6(2), appoint a Director of Public Prosecution in respect of an office of the Prosecuting Authority established by Section 6(1). Do you confirm that?
I confirm that, Chairperson.
Yes. Meaning that for each office of the NPA established at the High Court, there shall be a director headed who shall head it. Now, I want us then to jump and go to Section 20.
I am there, Chairperson.
Section 20 of the Act, under Chapter 4, provides for the power to institute and conduct criminal prosecutions, proceedings. Do you see that?
I confirm the, Chairperson.
And then it says that the power contemplated in Section 1792 and all other relevant sections of the Constitution to institute and conduct criminal proceedings on behalf of the state, carry out necessary functions incidental to instituting and conducting such criminal proceedings, and discontinue, vest in the prosecuting authority, and shall, for all purposes, be exercised on behalf of the Republic. Do you confirm that?
I confirm that, Chairperson.
Yes. And then, subsection 3 says, subject to the provisions of the Constitution, any director, subject to the control and directions of the National Director, exercises the powers referred to in subsection 1 in respect of A, the area of jurisdiction for which he or she has been appointed. Do you confirm that?
I confirm that, Chairperson.
Meaning that a director shall exercise the power to institute and conduct prosecution, carry out any necessary functions incidental to and or discontinue criminal proceedings only in respect of the area for which he's been appointed.
That is correct.
Yes. And
sorry, Advocate Mtsweni, if you say only in the area of jurisdiction for which he or she has been appointed, aren't you misreading the provision because it says subject to the control and directions?
we'll get to that, Madam. I'm gonna still take it.
Yeah, but I was trying to avoid the situation where we put a proposition to a witness which may not be entirely correct.
Okay. So, just so that we correct it, subsection 3 says any director shall, subject to the control and directions of the National Director, exercise the powers in respect of the area of jurisdiction for which he or she has been appointed. Do you confirm that?
I confirm the, Chairperson.
And any offence which have not expressly been excluded from his jurisdiction, either generally or in a specific case by the National Director. Do you confirm that?
I confirm the, Chairperson.
Yes. Now, then comes subsection 5, which then provides for a different situation in respect of prosecutors, which says any prosecutor shall be competent to exercise any of the powers referred to in subsection 1 to the extent that he or she has been authorized thereto in writing by the national director or by the person designated by the national director. Do you see that?
I can see the Chairperson.
Meaning that for what we now know is that although a prosecutor may be appointed for a particular jurisdiction or office, he or she can exercise those powers outside the area of jurisdiction if authorized to do so by the national director or any person designated by the director.
If authorized thereto
In writing.
In writing.
Yes. Right?
Yes.
And then subsection A provides that a written authorization referred to in subsection 1 shall set out the area of jurisdiction, the offences, and the courts in respect of which such powers may be exercised.
That is correct, Chairperson.
Yes. Now, we then go and look at the powers, duties, and functions of the national director, meaning the NDPP. That is set out in section 22. Section 22:1 says, the national director is the head of the prosecuting authority, shall have authority over the exercising of all the powers and performance of all the duties and functions conferred or imposed or assigned to any member of the prosecuting authority by the Constitution, this Act, and any other law. Meaning that he can institute, he's got a carte blanche, basically.
You are reading now section 22.
1.
Thank you.
Meaning that the national director can exercise those powers that prosecutors can exercise.
Yes. And then, in subsection 2 then deals with his powers to determine prosecution policy and issue policy directives. That is not relevant for this purpose. And it says may intervene in any prosecution process when policy directives are not complied with.
That is correct.
So in other words, it does recognize that even though he or she's got the power to exercise the prosecutorial functions, but such he or she can only intervene in another where such powers are being exercised by someone else if the prosecution process or policy directives are not complied with.
I agree, Chairperson.
Yes. And then it says, C, may review a decision to prosecute or not to prosecute after consulting the relevant director and after taking representations within the periods specified by the national director of the accused person, the complainant. That is not necessary for now, but we'll deal with it later. Now, subsection 3 provides for a direction by the national director to have a matter that would have been tried in the jurisdiction of another DPP, tried in a different jurisdiction. Do you confirm that?
I confirm that, Chairperson.
And it says, where the national director or deputy national director authorized thereto in writing by the national director deems it in the interest of the administration of justice that an offence committed as a whole or partially within the area of jurisdiction of one director be investigated and tried within the area of jurisdiction of another director, he or she may, subject to the provisions of section 111 of the Criminal Procedure Act of 1977, in writing direct that the investigation and criminal proceedings in respect of such offence be conducted and commenced within the area of such other director. Do you see that?
I see that, Chairperson.
And then subsection 4 provides for additional powers. It says that in addition to any other power, duties, and functions conferred or imposed or assigned to the national director by section 179 or other provision of the Constitution, this act or any other law, the National Director as the head of the prosecuting authority. And then it says, with a view of exercising her powers in terms of subsection 2, may, 1, conduct any investigation he or she deems necessary in respect of a prosecution or prosecution process, directives, directions, guidelines given or issued by a director in terms of this act, a case or matter relating to such prosecution or prosecution process, or directives or directions and guidelines. Do you see that?
I see that, Chairperson.
And then I'm not going to go to Roman figure 2 and Roman figure 3. And then C, it says, shall maintain a close liaison with deputy national directors, the prosecutors, and legal profession and legal institutions to foster common policies, practices, and to promote cooperation in relation to the handling of complaints in respect of prosecuting authority. Do you see that?
I see that, Chairperson.
And then it's C, may consider such recommendations, suggestions, and requests concerning the prosecuting authority as he may receive from any source. Do you confirm that?
I confirm the, Chairperson.
And then says, shall assist directors and prosecutors in achieving the effective and fair administration of criminal justice. Do you see that?
I see that, Chairperson.
And then says, shall assist deputy directors, and prosecutors in representing their professional interest. Do you see that?
I see that, Chairperson.
And then shall bring the United Nations guidelines on the role of prosecutors to the attention of directors and prosecutors and promote their respect for and compliance with the above-mentioned principles within the framework of national legislation. Do you see that?
I see that, Chairperson.
And then G, shall prepare comprehensive report in respect of operations of the prosecuting authority, which shall include, and I think that just deals with the administration. And then I want us to go to subsection 8, which says the national director or person designated by him or her in writing may, A, if no other member of the prosecuting authority is available, authorize in writing any suitable person to act as a prosecutor for the purpose of postponing any criminal case or cases. To confirm that?
I confirm that, Chairperson.
Yes. And it says, authorize any competent person in the employ of the public service or local authority to conduct prosecution subject to the control and directions of the national director or a person designated by him or her in respect of which such statutory offences, including municipal laws, as the national director in consultation with the minister may determine. Do you see that?
I see that, Chairperson.
And then the last one is the national director or any deputy national director designated by the national director shall have the power to institute and conduct prosecution in any court in the Republic in person. You confirm that?
I confirm that, Chairperson.
Now, the reason I took you through this is because I was hoping that you and we would find a clause that authorizes the national director to authorize a DPP to perform the functions of another DPP. And we couldn't find it. Do you confirm that?
Expressly, it
Yes.
is not there, yes.
It's not there.
Yes.
Yeah, and we know that a DPP, being an organ of state, can only exercise the powers that have been expressly conferred upon him or her by the law.
I agree, Chairperson.
Yes. Now, where the Act does not give him the power, then we can accept that he doesn't have the power.
I agree, Chairperson.
Yes. Now, I'm going to skip 23 and go to 24, which deals with the powers, duties, and functions of directors and deputy directors.
I see that, Chairperson.
On the point that you made, Council, the last point that we made in relation to what the law provides in relation to the NDPP's powers authorizing any person, any other prosecutor or any other DPP to perform the functions of another DPP. And the answer is that the Act does not expressly provide for that.
Yes.
Can you take this point to its logical conclusion?
It will become clearer, Madam Chair. Can I just ask you
Later.
to be patient?
Yes.
It will become clear. We're just laying foundation for what is yet to come.
Okay.
Yes. Now,
Of course, I'm always patient.
thank you, Madam Chair. Now, Adv Maema, on Section 24, it provides for the powers and the duties of directors and deputy directors. And subsection 1 says, subject to the provisions of Section 179 and any relevant section of the Constitution, this Act, or any other law, a director referred to in Section 13.1. Remember, a director, that would be the DPP.
That is correct, yes.
In respect of the area for which he or she has been appointed, right?
Yes.
Now, the power to, 1A, institute and conduct criminal proceedings and carry out functions incidental thereto as contemplated in Section 20 sub 3. Confirm that.
I confirm that, Chairperson.
And then it says, B, supervise, direct, and please bold the word, coordinate the work and activities of all deputy directors and prosecutors in the office for which he or she is the head. Do you confirm that?
I confirm that, Chairperson.
Yes. And then C, supervise, direct, and coordinate specific investigations. Do you confirm that?
I confirm that, Chairperson.
Right? And carry out all duties and perform all functions and exercise all powers conferred or imposed on or assigned to him or her under any law which is in accordance with the provisions of this Act. Do you see that?
I see that, Chairperson.
Now that we've dealt with the Act and we know what the Okay, let's just deal with subsection 4 before I missed it. Subsection 4 of Section 24 says, in addition to any other powers, duties, and functions conferred upon or imposed upon him or her by Section 179 of the Constitution, this Act or any other law, the director referred to in Section 13.1 shall at the request of the National Director submit reports to the National Director or assist the National Director in connection with a matter referred to in Section 22.4a Roman figure 2. Do you confirm that?
I confirm that, Chairperson.
And then B provides for the submission of annual reports, right?
I can see that, Chairperson.
And then it says, may in case of a director referred to in Section 13.1a, give directions or furnish guidelines to Roman figure 1, the Provincial Commissioner of Police Service referred to in Section 2073 of the Constitution within his area, Roman figure 2, any other person who within his or her area of jurisdiction, A, conducts investigations in relation to offences, or B, other than the private prosecutor, institute carries on prosecution for offences and shall, subject to the directions of the National Director, be responsible for the day-to-day management of deputy directors and prosecutors under his or her control. And we know that the directors and the deputy directors and prosecutors under his control are those that have been appointed for his office.
That is correct, Chairperson.
Yes. Now, Adv Maema, I just want us, we now know, now that we've conversed, there's a provision that I'm missing here from my note. I don't know what happened to it.
Speaking to yourself on the mic.
Apologize, Madam Chair. Okay, I'll come back to it when I find it. But over and above the act which regulates the conduct of prosecutors, directors, and national director, also the NPA Code of Ethics applies. Am I correct?
You are correct.
Yes.
Chair.
And Madam Chair, I'm just going to ask, and I know that Mr. He has offered to assist me in beaming the documents. I'm just going to ask him if he can just beam the following documents. I omitted to ask him to bring the bundles, but it's under the PD bundles.
You asked who?
The Mr. Gatlego here to assist me.
Yes.
He will beam it for
you
Mr.
can ask our receptionist to help you. Yes. Mr. Gatlego, what's your surname?
It'll be
I beg your pardon? Mr. Mtsweni. Advocate Mtsweni, not Mr. Gatlego, Mr. Mtsweni. We address people by surnames.
I've always called him Gatlego, but now I know he's Mr.
We are in a hearing here.
I think, Madam Chair, PD 00025. But the document itself,
PD,
the document itself starts
PD
00019.
PD 00019.
That is the Code of Ethics. Now, Mr. Maema, that is the Code of Ethics that's applicable within the NPA. Do you confirm that?
I do, Chairperson.
Now, I want you to go to PD 00025. Under to whom does the code apply?
I'm there, Chairperson.
And it says that this Code of Ethics applies to all NPA employees. Do you see that?
That is correct, Chairperson.
Yes, I'm not going to read the rest. And when I say employees, that would mean the National Director, Deputy National Directors, Directors, and Deputy Directors, everyone within the NPA.
That is correct, Chairperson.
Yes. And PD 00026. But before we move on, just go to PD 00024. I apologize for the back and forth, Madam Chair. 00024?
24.
Yes. Where it says our vision, mission, and core values.
I'm there, Chairperson.
I'm going to read the second paragraph, where it says, our core values of accountability, credibility, integrity, professionalism, and service excellence guide our behavior and directly support our vision and mission. Our core values form the basis of our culture and reflect the standards of acceptable conduct in the NPA. They therefore form the foundation of what our stakeholder should expect of us and what we should expect of them. Do you confirm that?
I confirm that, Chairperson.
And then we go to PD 00026. Which provides for the enforcement of the code.
At paragraph 3, yes.
And then I'm going to read it. I'm going to read the second paragraph. It says, as NPA employees, we need to ensure that we are familiar with this code of ethics. Failure to comply with the code or report or take action in respect of unethical or illegal actions will be dealt with in accordance with the applicable disciplinary rules and procedure for bringing the NPA into disrepute. Do you confirm that?
I confirm that, Chairperson.
Yes.
Council, where are you reading? Is it PD 00026?
Yes.
Enforcement.
Yes, enforcement of our code. The first paragraph, Madam Chair.
Because we take our values seriously.
Yes. But I just read the second sentence, starting from the second sentence.
Would you please read it again?
Okay, I'm just going to read it in its entirety, Madam Chair. It says, because we take our values seriously, we will take action against employees who do not abide by the conduct provisions of this code. As NPA employees, we need to ensure that we are familiar with this code of ethics. Failure to comply with the code or report or take action in respect of unethical or illegal actions will be dealt with in accordance with the applicable disciplinary rules and procedures for bringing the NPA into disrepute. In cases of serious infringements, this may lead to termination of employment. Do you confirm that?
Confirm that.
Yes.
I confirm that, Chairperson.
What I want is, I want to go to the values themselves. And in particular, at PD 00028.
I'm there, Chairperson.
And under paragraph 4.2, credibility. Do you see that?
I can see that, Chairperson.
And then I'm going to read it. It says, credibility means being reliable, sincere, and transparent in the manner we conduct ourselves by. Bullet point 1. Giving honest and impartial advice, maintaining confidentiality of information, protecting the NPA's name and reputation. Do you see that?
I can see that, Chairperson.
Yes. And then at 4.2.1 on PD 00029, it tells us what giving honest and impartial advice entails. It says, we will giving honest and impartial advice, we will base opinion on all available relevant information, evaluate information objectively, not make assumptions based on gossip or rumors, and evaluate only factual information. Do you see that?
That is correct, Chairperson.
Yes. And at 4.3.2, which talks about being honest, that would be PD 00030.
PD
00030.
30.
And it says, being honest, we will, A, always tell the truth and tell it in such a manner that it does not create false impression or mislead or deceive. B, make every effort to keep any or all promises made to fellow employees and NPA, suppliers, customers, and other stakeholders. Avoid making any false or misleading statements to others who may rely on the accuracy and truthfulness of the information being provided. D, conduct business with all stakeholders in a transparent manner. And E, not commit any crimes or illegal practices or actions. Do you see that?
I see that, Chairperson.
The reason I wanted to, I'm not going to go with you through the code, but I just wanted to emphasize that over and above the act requiring you to act in accordance with the rule of law, as I'm going to use the word prosecutors, but or as members of the NPA, you are required to conduct yourselves with utmost honesty and credibility.
That is correct, Chairperson.
Yes, those are the key and foundational values of a member of the NPA.
I agree, Chairperson.
And if any member is found wanting in respect of this, then he or she may not be fit and proper to be a member of the NPA.
I agree, Chairperson.
Yes. Now, let us then zoom into your evidence so that we can then just clarify your evidence. Now, Mr. Maema, when I read and having listened to your evidence and having gone through your resume, I'm not going to say you come across, because that will be an understatement. You are a very highly experienced prosecutor. Am I correct?
Thank you, sir.
But I just want to, yes. So, but you confirm that when one reads your resume, one can conclude that you are a highly experienced prosecutor.
I agree. I agree,
Yes.
Chairperson.
And your experience spans to a point that at some point you even acted as the head of your office for which you are appointed.
That is correct, Chairperson.
Yes. And also, when one reads your resume, as you set it out in your statement, you also have quite you've got you are experienced when it comes to racketeering matters.
I agree, Chairperson.
Yes. And in fact, you tell us that you believe you were roped in or brought into the prosecution team of the Cato Mena based on your experience.
That is based on the experience as well as a recommendation from the investigator, from General Mabula.
Yes. But also, when one looks at the team members, your co-prosecutors, I'd call them your co-prosecutors, Advocate Mtsweni, he's also when one looks at his resume, he's also highly qualified, highly experienced prosecutor.
That is correct, Chairperson.
In fact, Advocate Mtsweni tells us this in his own words. In his affidavit, in his statement which he submitted at the state capture, Madam Chair, that you would find on LO. I know I'm going to be in trouble with this, but I still have not familiarized myself with the volumes. But it's LO 341, 00341. It's LO3, it starts at LO340, but what I'm interested in is paragraph 26 of Advocate Mtsweni's statement. No, in fact, it's 27.
You said it's paragraph 26.
27. Let's go to paragraph
Oh,
27,
27.
Madam Chair. That would be LO 00348.
Yes, Councillor.
He tells us, you can read it at your leisure, Mr. Maema, but what is important is that Advocate Maema tells us, Mtsweni, sorry, I apologize, from paragraph under the heading NPA Head Office 2012 to 2019. And he says that, I'll just start from 26 so that, because it puts out the context, says, during 2012, the then acting NDPP called me to head the Special Projects Division, SPD, within the office of the NDPP, which by then was managed by the then Special Director of Witness Protection, Mr. D. Adam. This was to allow Adam to return to his responsibilities as the head of WP. The SPD consisted of a team of prosecutors, which developments arose out of the establishment of the OCI during 2006-07 and fulfilled the role of national coordination function of the OCI. It started with the national coordinator as the national coordinator at head office in the National Prosecuting Authority Services, with prosecutors being added to assist in time. And then he says, at paragraph 27, the mandate of this coordination function was to coordinate OCI by developing jurisprudence, primarily the implementation of POCA, providing training the NDPP on the authorization of racketeering prosecutions and doing matters incidental to organized crime, such as stakeholder management with law enforcement entities. Do you see that?
I see that, Chairperson.
And at 31, he says, my team was very effective in dealing with all kinds of matters that required the NDPP's approval, including authorizations, including centralizations, racketeering applications, Section 105 applications, and Section 47(2) of RICA. From 2012 to about 2018, we dealt with over 100 applications for racketeering. Do you see that?
I can see that, Chairperson.
So basically, when one also equally reads Advocate Mtsweni's, what Advocate Mtsweni tells us, he's very highly experienced.
That is correct,
Yes.
Chairperson.
And I would take it that would also include the other members of the team you advocate for Chanes, your Mlochos, and the others. They were very experienced.
That is correct, Chairperson.
So basically, this is a team that was put together based on its experience. And it was regarded as the team that would deliver on the mandate. That is to look at these dockets and, if need be, prosecute. Am I correct?
Correct. That is correct, Chairperson.
Yes. And in other words, one can then accept that you did not require to be babysitted or to be micromanaged.
That is correct.
Yes.
Chairperson.
And in fact, to confirm that, at paragraph 25 of your statement, that would be 1-7, Madam Chair, paragraph 25. Are you there, Mr. Maema?
I'm there, Chairperson.
Sorry if when I say Mr. Maema, it does not mean that I'm disentitling you of your title of advocate.
I accept that, Chairperson. Thank you.
Yes.
It's paragraph 5 of
25.
25.
Yes. In fact, I think I got the wrong paragraph, but what you said in the introductory part of your evidence was that Advocate Chauke never took any prosecutorial decisions here. Everything was done by you, the prosecuting team themselves. Do you recall that?
Yes, in respect of the decision to charge General Johan Boyce.
Yes. And from what we understand, you joined the team on the 9th of March, 2012.
That is correct, Chairperson.
Yes. And at that time, the only thing that you had, when I say you, I mean you and your team members, were the so-called 6 to 8 dockets.
Yes, on the 9th of March, after that meeting, Advocate Mtsweni handed us those.
Yes. I'm talking about at that time, you
Yes.
only had 6 to 8 dockets.
That is correct, yes.
And at that point in time, there had not been any decision taken as to who must be charged, whether you must charge or not.
That is correct, Chairperson.
Your task was to look at them, assess them, and then, if needs be, guide the investigation.
That is correct.
So that at least then you are in a position to gather all the evidence to a point that you can take an informed decision.
That is correct, Chairperson.
Yes. Now, you said to us that Advocate Chauke, I'm sorry for repeating myself, was the coordinator of the prosecution team.
That is correct.
Yes. Now, I just want to invite you to go with me on a journey so that we examine what is it that Advocate Chauke did in his coordinating role. And I think the best place to look at would be Advocate Chauke's own words. That would be his affidavit that he deposed to in the state capture as well, under paragraph at LO 243.
Counsel, I don't mean to disturb your line of questioning the witness. You had earlier on referred us to paragraph 25, and we are still there.
No, I said I went to a wrong paragraph, Madam Chair. I apologize. I wanted the paragraph where he had said that Advocate Chauke was playing a coordinating role.
Yes.
And then he confirmed that he testified to that effect in his evidence.
Is that the paragraph you are referring to now?
No, I'll find the paragraph and I'll refer to it.
Okay. You are now examining what Advocate Chauke did
In his coordinate as a coordinator.
as a coordinator.
Advocate Mtsweni, maybe to assist, you were on the correct paragraph. Paragraph 25 is just that it starts at line 4 of that paragraph.
Thank you, Madam Advocate, Madam Mere. I see. Now, are you at Advocate Chauke's affidavit in Adv Maema? That is LO 00243.
Yes, I am there, Chairperson.
And then, at paragraph 1 of that affidavit, right, Advocate Chauke tells us the following. He says, I'm an adult male Director of Public Prosecutions of South Gauteng Division of the High Court, Johannesburg, situated at corner Pritchard and Grey Street. Do you see that?
I see that, Chairperson.
Basically, it tells us that I have been appointed for the office of the South Gauteng.
That is correct, Chairperson.
And we know that in terms of the Act, Advocate Chauke can only exercise control for those functions, or whatever functions that are given to him, only in respect of his office.
That is correct,
Yes.
Chairperson.
But let's go and look at what, and then at if we then go to LO267,
LO
00267.
00267.
Yes, Madam Chair.
I am there, Chairperson.
Now, Advocate Chauke at paragraph 62 tells us what his role as the team coordinator was. And then he says, my role as team coordinator was deal with the logistics and administrative matters of the prosecution team, ensuring coordination between various stakeholders. My involvement excluded taking prosecutorial decisions whether to prosecute or not, feedback on briefing team to JIBA, including the submission of documentation to the from the prosecution team to the NDPP. Do you see that?
I see that, Chairperson.
Yes. And then at paragraph 64, he lays out a number of what he did, of instances of what is it that he did in his role, and it's going to take us a while, but we unfortunately it's an exercise that we have to do. First, he says at paragraph 64. On the 3rd of May 2012, I attended a briefing meeting with JIBA, during which it was arranged that the prosecuting team brief her on the Cato manner on 18 May 2012. On 15 May 2012, I attended a meeting with the prosecution team to prepare for JIBA briefing. Do you see that?
I can see that, Chairperson.
And then,
I'm sorry, I'm lost.
Madam, paragraph 64,
64 of
Advocate Chauke's affidavit. That would be LO2.
LO2.
Yes. No, LO267. I'm not sure whether is it in that paragraph.
This one. Okay, thank you.
Did you see that? Thank you, Madam Advocate Maema. And then he then says, on the 17th, firstly, on the 3rd of May, he attended a briefing session with Advocate JIBA, during which it was arranged that the prosecution team will brief her on the Cato matters on the 18th of May. Do you see that?
I can see that.
And then on the 15th, he attended a meeting with you to prepare for the JIBA briefing.
That is correct, Chairperson.
Yes. Right?
It's correct to say the prosecution team,
Yes.
not you.
Okay.
Because it may be misleading.
Okay. Thank you, Madam Chair, for the guidance. And then he then tells us at 65, it says, during the meeting on the 17th, May 2012, Maema and Matenja raised security concerns, and then their concerns were that the police suspects in KZN always had knowledge of the prosecution team's visit to Durban in the matters, despite such information being shared with JIBA. Mloja and myself, they were concerned that one or all of our security were compromised. I reported the concerns to JIBA and the head of risk and security at NPA. Do you see that?
I can see that, Chairperson.
Then on the 22nd, he held a meeting with Mokoena, Angus, and the prosecution team where the security issues were discussed, because the Cato Manor team had similar experience about knowledge of suspects about the investigation. Do you see that?
I see that, Chairperson.
Then at paragraph 67, he said he held a briefing with the prosecution team in preparation for briefing JIBA Advocate Jiba on the 24th May 2012. Do you see that?
I see that, Chairperson.
We now see that every time, this is the second time that as the prosecution team, before you can brief Advocate Jiba, Advocate Chauke holds a meeting with the prosecution team in preparation for that briefing. Is that correct?
That is correct, Chairperson.
And this is despite the prosecution team being comprising of highly experienced and trained prosecutors.
That is correct, Chairperson.
Yes. And then he tells us that on the paragraph 71, on the 29th May 2012 in Cape Town, Jiba and myself had a meeting with the Minister of Justice. The Minister was provided with an update, I think I want to say with an update in the matter regarding the indictment, the nature of the progress in the case. The meeting was held for the Minister to understand the nature of this high-profile case. This in turn enabled the Minister to exercise his responsibility in terms of his mandate as the executing authority. Do you see that?
I see that, Chairperson.
He's no longer just dealing with the team, prosecution team. He's now gone as far as briefing the Minister on these matters. Do you see that?
I see that, Chairperson.
Yes. And then he says, on the 7th of June 2012, the prosecution team, Jiba and myself, attended a meeting at OR Tambo International Airport regarding security concerns raised as mentioned above and various issues regarding the progress of the matter. Do you see that?
I see that, Chairperson.
So basically, every time you're there to speak to Advocate Jiba, he's present. Do you see that?
That is correct, Chairperson.
To paragraph 71.
Yes, Madam Chair.
What you said earlier, I suppose you are paraphrasing paragraph 71.
Yes, yes, Madam Chair.
You say, Chauke then briefs the minister.
No, I'm saying he's no longer involved in just managing the team.
Yes.
He's involved in meetings where the minister is being briefed.
Where the minister is being briefed.
Yes.
Yes, thank you.
Can I proceed, Madam Chair?
Yes.
And then he then says again, on the 11th of
It
June...
might just be helpful for the purpose of the record, just to read that paragraph.
Paragraph 71?
Yes.
Okay, let me just, as per direction says, on 29 May 2012 in Cape Town, Jiba and myself had a meeting with the Minister of Justice, open bracket, the Minister, close bracket. The Minister was provided with an update in the matter regarding, it says with an updated, I think it wanted to say update, but I'll just read, with an updated in the matter regarding the indictment and the nature of the progress of the case. This meeting was held for the Minister to understand the nature of this high-profile case. This, in turn, enabled the Minister to exercise his responsibility in terms of his mandate as the executive authority. Close quote. I'll then move on, Mr. Maema. And then he then says, on the 12th June, I held a meeting with the prosecution team and Major Mabula on the progress of the investigation and related issues. Do you see that?
I see that, Chairperson.
I'm going to park it there and deal with something else and it'll become clearer. We know that from your evidence, you testified that you held a meeting on the 9th of March 2012 and it was at that meeting where two things happened. Firstly, you were given the 6 to 8 dockets. Do you recall that?
That is correct, by Advocate
And
Mtsweni.
you were announced as the team leader.
That is correct, Chairperson.
Yes. And then, At that time, the only dockets that you had were those 6 to 8. Am I correct?
That is correct.
And you then testified that you had other matters to finalize in Mahikeng, and then but the prosecution team went down to KZN in order where they were given the other dockets.
That is correct, yes.
Right? And then you said, when they got those dockets, which was, and it was under the leadership of Matenja, they then started guiding some of the investigations in those dockets. Do you recall that?
That is correct, Chair.
Yes. And then you then joined the team for the first time in Durban on, okay, I'll assume it for the first time on the week of the 27th of May 2012. That's when you went down to Durban.
That is correct.
Yes. And then whilst you were there, you were given, that's when the team was given the rest of the dockets to sift through.
That is correct.
Yes. And at that time, the idea was you sift through the dockets, determine whether there might be a case to answer or not, and if not, you then guide the investigation so that you are in a position to make an informed decision.
That is correct, Chairperson.
Yes.
The question relating to the rest of the dockets refers to the 23 dockets, or which ones?
Chairperson, is the 23 dockets together with the other dockets that were handed to us, which we retained, which we decided not to focus on.
Yes. And you then said between from the week of the 27th May, you were attending in Durban on a weekly basis.
That is correct.
And at that time, you were still busy sifting through all these dockets.
Yes, we are analyzing the docket, guiding the investigations.
Yes.
Yes.
You had not taken the decision to arraign anyone.
That is correct, yes.
And you had not drafted any indictment.
That is correct.
Right? So therefore, if anyone says, and you said the decision to arraign, when you then decided to arraign, was taken, you then said you took the decision to arraign people on the 29th of June. Do you recall that?
I recall that.
Yes, and that is when you then embarked on the process of drafting the indictment.
That is correct, yes.
And therefore, if anyone says that prior thereto, you had drafted an indictment, that would not be correct. When is the prosecution team?
The prosecution team, remember the indictment is progressive. So we concluded drafting it, yes, towards the end of June.
Yes.
2012.
But before the end of June, there was no indictment that was ready to be signed.
Yes.
Now, I'm asking this because if we turn back to Advocate Chauke's affidavit, he says, on the 12th, June 2012, I received the draft indictment with summaries of the matters from the prosecution team. I have forwarded same to Mlojo through my PA. Do you see that?
Where?
Paragraph 75.
Oh, 75. Yes, it talks about a draft indictment.
Yes. But you just told us that you had not finalized the indictment at that point in time.
It was, if there would be an indictment, it would be unfinalized and it would be a draft indictment.
But then let's go on and see and hear what Advocate Chauke says.
Okay.
He says, on the 14th, June 2012, I attended the meeting at VGM NPA office with NDPP. In that meeting, arrangements were made that Maema will sign the indictment.
I see that, Chairperson.
Yes. Now, meaning that the indictment, in his view, was ready to be signed.
No, it does not mean that.
Yes. But then, let's go on. Are you aware that he sent the same indictment to Advocate Mtsweni, asking Advocate Mtsweni to sign the indictment?
I became aware here
Yes.
in the inquiry, and I also had the exchange that was referred to in the state capture.
And that was despite you, the prosecution team, not having finalized that indictment.
Sorry, before you answer, let me understand. Are you pegging that question on paragraph 676?
Yes, it follows that to say, well, he says he received the indictment on the 12th, and then on the 14th, he was making arrangements for Advocate Maema to sign the indictment with Advocate Jiba. Now, I'm saying to Advocate Maema that on his version, they had not yet finalized the indictment, and yet Advocate Chauke is already making arrangements for the indictment to be signed.
But shouldn't we have regard to paragraph 75, where he says here that is Advocate Chauke, he received the draft indictment.
Yes.
Yes,
Now,
on 12 June.
that's correct, Madam Chair.
Yes. So what is the point that you're making? I just want to understand
That-
clearly what
That
point is.
document being a draft, and
Yes.
according to Advocate Maema, it not being a final document, Advocate Chauke was already making arrangements for it to be signed.
Would you just give me a second? Let me record your question. Now, following paragraph 75, after receiving that draft indictment, on the 14th of June meeting at VGM, in that meeting, arrangements were made that Maema will sign the indictment. Is the point that we are making?
Yes.
And who had made those arrangements?
It was Advocate Chauke making them with Advocate Jiba.
Correct?
Chairperson, I did not know about those arrangements. They were never communicated to me.
Madam Chair, could I just ask my learned friend to point us to the page where Mr. Chauke instructs Mr. Mtsweni to sign the indictment?
Yes, I'm on that point because I'm lost. That's why I'm asking counsel to assist me. From when you read from paragraph 75, that's why I took counsel there. Advocate Chauke says, on 12 June 2012, I received a draft indictment with summaries. I forwarded same to Advocate Mtsweni through my PA. 76. On 14 June 2012, I, Advocate Chauke, attended a meeting at VGM head office. In that meeting, it's Advocate Chauke speaking, arrangements were made that Maema will sign an indictment. That is why I asked you, who made the arrangements that Advocate Maema will sign the indictment?
Madam Chair, he tells us in his affidavit that he attended a meeting. If one reads, just want to get to the document again. He says at paragraph 76, on 14 June 2012, I attended a meeting at VGM NPA head office with NDPP. In that meeting, arrangements were made that Maema will sign the indictment. So meaning that the arrangement was being made between him and the NDPP. Advocate Chauke, because he said he attended, he does not tell us that there was anyone in that meeting, it was him and the NDPP. Because it says, I attended a meeting at VGM, NPA, head office with NDPP. And he doesn't tell us that there was anyone else. And then he says, at that meeting, arrangements were made that Maema will sign the indictment.
Yes.
Yes.
Yes, what is...
And the point is, the prosecution team had not finalized the indictment, and yet Advocate Chauke is already making arrangements with the NDPP that Maema will sign.
Just as a point of clarity, is there something wrong in making arrangements beforehand?
Madam Mere, it will become clearer once I've gone through this. If I can just ask that I'll note your question, and then you will understand very soon why we're dealing with that.
I'm a bit worried because when you started your line of questioning, I know that my sister here asked you a question and you said she must be patient, and I take it she's been patient, but we haven't gotten to where you were going.
We will get there very soon.
Okay, thank you.
Yes. So,
I still register my objection. My learned friend says that Advocate Chauke instructed Advocate Mlojo to sign an indictment. He must take us to the page where that instruction appears.
No, Madam Chair, I retract that question. It was a mistake. I shouldn't have said that. I retract that question and that statement. I did not mean to put it that way. I just wanted to say he forwarded the indictment to Advocate Mlojo.
Yes.
And then
that's why I read paragraph 75 to you.
Yes.
It was on that basis.
Yes,
that,
no.
I
accept.
Wait a minute, let me finish. It was on that basis that this exchange happened.
I accept the thank you, Madam Chair. I think I wanted to simply leave it there and not go on the instruction point.
Yes.
I will not pursue that he was instructing Advocate Mlojo to sign.
Thank you.
Yes. Now, after you were appointed to the team, right? You got written authorizations from the acting national director.
That is correct, Chair.
And the authorizations authorized you to conduct criminal prosecutions in respect of these matters for KZN, in KZN.
First commencement with the assessing of the evidence, reviewing it, and then if there is evidence, yes, then dealing with that resultant prosecution as well as any subsequent reviews or appeals.
Yes. So therefore, for all intents and purposes, when dealing with these matters, you were a KZN prosecutor.
No, Chairperson, I was a prosecutor.
Please, let's be very careful and Advocate Mtsweni. You remember he was a head of a team, a prosecution team. So when you address these issues, address them to him as the
Is it-
head,
Oh,
who was working in collaboration with other members of the
Yes.
team. But
Okay.
because if you say you,
I'll do my best. I'll
it
just
might just confuse the record at a later stage.
let me just make a note so that I can always remind myself. Just put it here. Okay.
Unless, of course, there is anything that you say him personally, individually.
No, Madam Chair. I will not ascribe anything. If I have to ascribe something personally to him, I will tell him. Yes. Now, Advocate Maema, when all the prosecution team members got similar authorizations, am I correct?
That is correct. We got authorizations as Advocate Matenjo and I from the national director,
Yes.
and the senior state advocates got their authorizations from the Director of
Yes.
Prosecutions, Advocate Andrew Chauke.
Yes, but the prosecution team, when dealing with these matters, were for all intents and purposes KZN prosecutors.
No, they were all authorized to deal with that prosecution in KZN.
Yes.
Yes,
Yes.
In relation to the Gauteng matters.
that is correct, Chairperson.
It is important to
Yes.
go
No,
there
the hence I said in these matters.
in these matters.
Yes. Hence I used the word in these matters. When I say it, just for the record, with these matters, I'm referring to the Gauteng matters.
I follow, Chairperson.
Yes. And that, we know that KZN was under the leadership of Advocate Mtsweni.
That is correct.
Yes.
Advocate Andrew Chauke.
Yes. And hence you were authorized to go and prosecute in Advocate Mtsweni and to conduct all matters necessary thereto, the prosecution team.
That is correct,
Yes.
Chairperson.
Now, we know that in terms of the NPA Act, the power to coordinate the affairs and matters relating to prosecutors, because now in this case, you through the authorization, you have sort of seconded to Advocate Mtsweni's office, the prosecution team.
Secondment is a different concept than
No, say assigned. Let me use the word assigned.
assigned would be more appropriate.
Yes.
It accords with Section 24(4)(b).
Yes, so you were assigned to Advocate Mtsweni's office.
You were assigned to deal with the prosecution of the Gauteng matter,
Yes, which fall under Advocate Mtsweni's office.
which should ordinarily have been dealt with in Advocate Mtsweni's office. Yes,
But remember, Advocate Mtsweni is the DPP of KZN,
that is correct.
and he is in charge of all matters within the province,
That is correct.
right? So therefore, the Gauteng matters were under Advocate Mtsweni's jurisdiction.
That is correct. Yes.
Yes, and
Was your answer to that question that the power to coordinate matters relating to Advocate Mtsweni's office, was it to deal with matters which should ordinarily be dealt with by Advocate Mtsweni?
That is correct, Chairperson.
That is the answer that you gave.
Yes,
I just wanted to check whether I heard that we should ordinarily.
And we know now that you were assigned to Advocate Mtsweni to go and prosecute these matters, which, and Section 24(1) tells us that the DPP, the director being Advocate Mtsweni, in respect of the area for which he has been appointed, has, amongst others, the power to institute and conduct criminal proceedings and to carry out functions incidental thereto as contemplated in Section 20(3). Do you recall that part?
Chairperson, you said Section 24. I'm not sure whether you
Section 24(1)
24.
of the NPA Act.
I remember it so, yes.
And B says he's got the power to supervise, direct and coordinate the work and activities of all deputy directors and prosecutors in the office of which he is the head.
That is correct, Chairperson.
Yes. So basically, the power to coordinate, because the prosecution team was assigned to his office to prosecute these matters, the power to coordinate, to supervise, coordinate, and direct the prosecution team's work and activities vested in Advocate Mtsweni.
I do not necessarily agree with that version.
But that's what the Act says.
Yes, but remember when Advocate Mtsweni as a appointed DPP requests that a team from outside deal with the matter, then it changes the complexion of what the Act says.
But Advocate Mtsweni did not relinquish his powers in terms of the Act. Do you agree with me?
I agree, yes.
And in fact, in terms of the Act, he does not have the power to delegate those functions, to relinquish those powers.
I do not follow.
He cannot, I think let's leave it. We've already agreed that he did not relinquish his powers in terms of the Act.
Yes.
And that is the power, amongst others, to supervise, direct and coordinate the work and activities of all the deputy directors and prosecutors in the office which he is the head.
That is correct, yes.
Yes. And now, meaning that the power that Advocate Chauke exercised ought to have been exercised by Advocate Mtsweni, being the coordination power.
Chairperson, the institution must function. We are based in an office, and because we have a DPP there, we need information communicated to the DPP. We speak to the DPP in that office to do that coordination wrong, because we did not see anything wrong in asking Advocate Chauke to do the
point,
communication.
I get that, we'll deal with it, but the point is that power, the power to coordinate in terms of the Act vested with Advocate Mtsweni.
I agree.
Yes, not Advocate Chauke.
I agree.
Yes. And we know already that in terms of the principle of the rule of law, which you agreed with me earlier, that as the officials of the NDPP, you can only exercise those powers that the law confers upon you.
I agree with you.
Yes. So therefore, if Advocate Chauke did not have the power in terms of the Act to exercise the coordination functions, he acted unlawfully.
I would not necessarily agree with that one.
Yes.
On the basis that it is an ancillary role to communicate, because when the primary prosecution decision has been done by the prosecutor delegated to do that function, the communication thereof is whether it's take it from the line of command that I spoke about. As a deputy, I do not speak to the national director. So I speak to the national director through the DPP. So whether I ask Advocate Smith, my DPP in the Northwest, to communicate to the national director, or whether I am in KZN, I ask Advocate Mtsweni, who would be the DPP there to communicate. The primary prosecution decision has been taken by the prosecutor.
I'm not talking about the prosecution decision here, Mr. Maema.
Yes.
I'm talking about the coordination function, which Advocate Chauke had admitted was his function, that was his involvement. That coordination function vested with Advocate Mtsweni.
And yes, I agree with you there, but all I'm saying is there is nothing wrong in the prosecution team asking Advocate Chauke, as we were physically in his office, to communicate the decision that we had.
I get the arrangement.
Yes.
We'll deal with the arrangement shortly. But the point is the following, that function, the coordination function, did not vest with Advocate Chauke.
Strictly speaking, in terms of the law, yes.
Yes. And we know that if someone conducts themselves in a manner that is inconsistent with the law, they are acting unlawfully.
Well, if it is a communication role which does not go to the heart of the decision making, I wouldn't necessarily say that is unlawful.
Now let's examine that. Whether was it only limited
Yes.
to the communication line?
Yes.
Before you examine that, I just want to get this correct in my mind. With regard to the Katomena matters, the DPP KZN, Advocate Mlojwa, had made a request and agreed that there should be an outside team.
That is correct.
I don't have the correspondence, but it's something to that effect.
That is correct, Chairperson.
Correct?
Yes.
He communicated that to the then acting NDPP,
That is correct.
Advocate Jiba.
Yes.
Following that, Advocate Jiba requested, and please correct me if I'm wrong,
Yes, Chairperson.
Advocate Jiba requested Advocate Chauke to coordinate a team of prosecutors.
That is correct, Chairperson.
And she then assigned her a coordinating role as regards this team.
The coordinating role, when it was assigned, Chairperson, I was not present.
No,
When I was
yes.
present on the 9th of March is when the prosecution team was put together and tasked to go and do the prosecution role in KZN.
Yes, we now know from the reading of this record that Advocate Chauke was assigned to coordinate.
That is correct, Chairperson.
And he specifically said that his role was not prosecutorial.
Yes, yes.
That was read to you earlier by Advocate Mtsweni.
That is correct, Chair.
Now, Council is dealing with those statutory provisions that tells us that a director in the position of Advocate Chauke had no such a power. This is against that background that I've just said to you.
Yes, Chairperson.
Had no powers to so coordinate because the legislation tells us so.
That is correct, Chair.
What should we make of that context, that background that I've now said to you, that the NDPP exercised her powers, the acting NDPP then exercised her powers following the request by Advocate Mlojwa to assign a team to deal with those matters in KZN. And Advocate Chauke was then, should I use assigned or delegated, to then coordinate those matters relating to Katomena.
Chairperson, my understanding of how the system works.
No, don't go to how the system works. I just want to understand the correctness of my understanding of how things developed.
Oh yes, the things develop exactly as how you have outlined it, Chair.
Yes, thank you.
Against that backdrop, do you recall that earlier when we examined the powers of the national director, we also agreed that there are no power, she's got no power to assign functions of another director to another director except where the matter is going to be prosecuted in the other director's jurisdiction.
Yes, I agree.
Yes. So therefore, again, if Advocate Jiba assigned Advocate Chauke the coordinating functions of the prosecution team, which was assigned to Advocate Mlojo, she actually contravened the act because she didn't have that power.
Chairperson, that is my basis for saying it's not unlawful. I'm saying it is not per se unlawful. There is nothing that prevents a national director to utilize his or her staff in any manner that she deems appropriate and in the interest of justice. So I didn't see anything wrong in that.
But I'm talking about the power to assign functions of another director. Not talking about how she chose to run her office. I'm talking about the assignment of a power of another director to another director. She didn't have that power.
When you're talking about the prosecution
function.
Yes.
Yes.
But a function which is ancillary to prosecution, I would assume that there is nothing in the act that prevents an ancillary function to be assigned to any
But there's nothing in the act that authorizes her to do that.
That is correct. I agree.
Yes.
Whilst there is nothing in the act saying you can do that, there is nothing in the act preventing from doing that.
Remember, Mr. Maema, we're not dealing with a stock file here. We're dealing with one of the more...
He said earlier, you remember when you asked him the question, he said, the Act does not expressly say so.
Yeah.
It is not proper to even try to say we are not in a stock file or not. It's not proper.
I retract that, Madam Chair.
You have to respect one another here.
I apologize,
As we
Madam.
respect you, you have to respect the witness.
I apologize, Madam
He's
Chair.
an advocate just like yourself.
I apologize again, Madam Chair. Mr. Maema, I apologize.
Accept the chairperson.
Yes. We have dealt with, and Mr. Maema, I believe that it will be a matter that the panel will have to deal with. Whether I get your view that you say it was not unlawful, but it's a matter that the panel will have to consider, because under clause 3.2 of the terms of reference, they have been invited to also consider Advocate Chauke's conduct in relation to these matters. So they will have to look at Advocate Chauke's conduct and vis-a-vis whether by exercising Advocate Mlojo's functions under the circumstances whether he contravened the act, and then they'll make the necessary recommendation to the President. I just wanted so that you understand the context.
I follow, chairperson.
Yes. But let us...
It may also be that if you persist with this line of questioning, that the right person to call as your witness will be acting NDPP, who exercised these powers that you say were unlawfully exercised because the Act does not give her such powers.
Madam Chair, we will, and we can make a note. We'll refer you to a judgment. I think it's a recent judgment.
No, I'm just saying it may well be in your interest as the evidence leaders, following this line of questions, to consider calling Advocate Jiba, who is the one who exercised the powers that you say she did not have.
I doubt so. We will consider it and
Yes, thank you, Chair. I just want to ask one question, Advocate Maema.
Yes, chairperson.
And that question is, where does a creature of statute derive its powers from?
From the very enabling statute.
Thank you.
Proceed, Advocate Mtsweni. I made that statement because your earlier point was, so Jiba contravened the Act. That's why I made that remark.
Thank you, Madam Chair.
Sorry, Advocate Mtsweni, just as a follow-up, Advocate Maema,
Chairperson?
let's assume for a second that the then acting NDPP contravened the act by asking or by assigning Advocate Chauke the role to coordinate, to be to oversee your team, your prosecuting team.
Yes, Chairperson.
Would it have been open to Advocate Chauke to refuse that assignment from the then acting NDPP?
No, Chairperson. I wouldn't imagine a situation where an instruction is given to an NPA official by the senior and the person who's given the instruction refuses it. It will be insubordination.
Thank you.
I suppose the assumption is made on the belief that Advocate Chauke would have understood that Advocate Jiba acted unlawfully.
Oh, yes.
And I think you should understand, Advocate Maema,
Yes,
that
Chairperson.
there is no, thus far, definitive finding about the lawfulness or unlawfulness of Advocate Jiba's conduct.
I follow, Chairperson. Thank you.
you.
Yes.
Just to try to understand the question and the answer in particular,
Yes, Chairperson.
is your understanding that the lawfulness or unlawfulness of Advocate Jiba's conduct is not the subject matter of this inquiry?
That is correct, Chairperson. Yes.
Is that what we are answering?
That is what I'm answering.
You may proceed, Counsel.
Thank you, Madam Chair. Advocate Maema, I think I've made the point about Advocate Chauke's. All those questions were aimed at demonstrating that Advocate Chauke had exercised in the coordination functions which did not vest in him but vested in Advocate Mtsweni. I think that point has been made. I just want us to move to the next topic, that of the centralization.
Before you go there, you remember how we exercised some patience with regard to this background that you set up. If you can just tie it up nicely for me to understand why we went all these routes in a summarized way, the legislative framework.
Madam Chair, okay, sorry. The entire exercise was, you would recall that in terms of amongst the issues that the panel has to consider. Now, amongst the issues that the panel has to consider is, in addition to whether or not Advocate Chauke was correct or not in supporting the prosecution, whether there was sufficient evidence or not, you're still invited under 3.2 to consider.
You should go to the terms of reference so that we get it right.
Yes, I just want to get to the...
Just make your statement in accordance with the terms of reference so that we understand precisely where you come from and where you were going to.
Sorry, Madam Chair, I'm just using Mr. Mahlakwane's computer here. It's not friendly to me.
We will assist you with the terms of reference if this is what you are looking at. My researcher will, if you have a copy, can have a look at that copy.
Thank you, Madam Chair. I've got the terms of reference. Madam Chair, if I'm not going to go into 3.1, but I'm going to go to 3.2, that one of the questions that the panel must look at is whether in fulfilling his responsibilities as the Director of Public Prosecution, Advocate Chauke, 3.2.1, complied with the Constitution, National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority is fit and proper to hold this position and be a member of the prosecution team. So you need to look at his conduct as a DPP.
Against the legislative
Again, and
framework.
hence we started off with the legislative background to say, well, that conduct must be looked at against the backdrop of what are the applicable prescripts within the NPA and what is expected of him.
Yes.
Yes, that was the basis, the background, Madam Chair.
Yes. And that's how you took us finally to Advocate Jiba's conduct
Yes.
having been unlawful,
Yes.
that he contravened the act.
Because, yes, Madam Chair, and just so that for the comfort of everyone, Madam Chair, we will at the end also avail to the panel authority that suggests that one cannot contravene the law on the basis that they were acting on instructions. And we will say that you must also find that Advocate Chauke, being a senior member of the prosecution team authority, was aware that he cannot break the law because he was acting on instructions.
Yes, you remember my question to him the last question, that when she said that, as my sister said, assuming the conduct was unlawful, could he have refused to act as he was assigned? And the answer was no. Then I made a follow-up question saying the assumption and the answer given should be understood on the basis that Advocate Chauke knew or believed that Advocate Jiba acted unlawfully. And he said yes. So it is against that legislative framework that you are setting up that why we are here.
Yes, Madam Chair.
Thank you.
Now, can I continue, Madam Chair?
You said your next topic is?
It's the centralization. And I think the relevant part that we will discuss, you and me, would be at LO 843.
Oh,
00843.
008.
I think it's under LO4, Madam Chair. LO3, I'm told, Mr. Mahlakwane.
LO3.
That's correct. (843).
I am there, Chairperson.
Council, you may proceed.
Advocate Maema, that is an application for centralization of charges in terms of Section 111 of the Criminal Procedure Act. Do you see that?
That is correct, Chairperson.
Yes. Now, you'd agree with me that the centralization is part of the prosecutorial decisions.
That is correct. It's ancillary to
Yes.
there too.
Now, what you see there, you see a document dated 15 August 2012, addressed to Advocate Jiba from Advocate Chauke. Do you see that?
That is correct.
Yes. And in that document, Advocate Chauke is applying to have one of the dockets which were linked to the Cato Mena dockets, which ought to, or the offense which was committed in Northwest, to be centralized and tried in KZN. Do you see that?
Chairperson, in actual fact, I am the person asking Advocate Jiba to...
No, let's look at the document.
Yes.
From whom is it from?
It is from Advocate Chauke.
Does it say Advocate Maema there?
I drafted this document.
No, Mr. Maema, I'm asking you, does it say Advocate Maema there?
No, it does not.
Exactly. So, therefore, as the reader, I can accept that this is a document that comes from Advocate Chauke to Advocate Maema, to Advocate Jiba, because it says from.
Yes.
Right? And then if you go to the 846,
Maybe before you proceed, Advocate Mtsweni, you put it to Advocate Maema that this document is a document of Advocate Chauke. And you took it further to say, but if one looks at the document, one will say that the document is from Advocate Chauke. Now, if a person, in particular Advocate Maema, then says to you, but I am the author or I am the owner of this document, does it remain a document of Advocate Chauke? Or what is the position? Or rather, maybe let me say, what does that type of answer do to your understanding that the document belongs to Advocate Chauke?
Madam Ramakaka, can I just ask this question, and it'll tie up with you so that I'll answer your question within a particular context.
Okay.
Yes.
That's fine.
Advocate Maema, I asked you to go to page 846.
846.
Yes, LO 846.
I'm there, Chairperson.
At the bottom there,
Yes.
right? Whose signature is that?
There is a signature of Advocate Chauke.
Yes. And what is your understanding when someone signs a document? What does it mean? What does it entail?
Well, it is a document. It is a document that Advocate Chauke signs.
Yes. So he takes ownership of the document.
Yes, you can say so.
Yes. So now, Advocate Madam Ramakaka, that is the point that I wanted to say, that even though Advocate Maema says it emanates from him, Advocate Chauke took ownership of that document by signing it.
I think you heard my question. The question still remains that if you look at a document, you see it is written from Advocate Chauke's office, and then you take it further to see the signature of Advocate Chauke. And the witness in the box says, it is my document nevertheless. Does it have any impact on the evidence before us? Or is it something that should be ignored or followed up in order to clear what your position is?
Madam Ramakagu will say that the witness's answer should be ignored because it's an afterthought. That's what we will submit at the end of the day.
Okay.
Yes.
You're talking about submissions at the end.
Yes.
Thank you.
But Advocate Maema, let's accept for I've heard your answer, where you said it's your document. But do you accept that when Advocate Jiba or anyone who reads this document looks at it, there's nothing that says Advocate Maema there?
Chairperson, there is nothing that says Advocate Maema.
Yes. So one then can accept that this application, since it says, according to this document, it emanates from Advocate Chauke, signed by Advocate Chauke, one can accept that it's an application made by Advocate Chauke.
Not necessarily.
But or looking at the document.
Well, you cannot look at the document in isolation. I indicated that the communication framework in the institution is Advocate Maema as a deputy director, whether he's in the Northwest, whether he's in South Gauteng, whether he's in KZN, he cannot communicate directly to Advocate Jiba. So when he's in the Northwest, he will communicate under the name of Advocate Smith, who would be the DPP. When he's in KZN, under the name of Advocate Noko or Advocate Mlojo, as he then was, because he's in KZN. When he's in South Gauteng, he will also communicate through Advocate Chauke. So when I was in South Gauteng, because as a deputy, I do not talk to the national director. I communicate through the mouth of Advocate Chauke. So that is why you see that the signature there. It is my document that I drafted, but I'm communicating to the national director. So for it to have efficacy, it must come from the DPP in terms of the NPA protocol.
Now let's go to 856.
Go there. 856. Before you go to 856, Council, let's go back to that document. The memo or letter by Advocate Chauke to Advocate Jiba dated 15 August 2012. When you get into the context of this letter, it becomes clear that at that time, a request for authorization had been made by Advocate Noko on the same date. If you look at NJ3, LO 00805. Advocate Noko had written to Advocate Jiba on the 15th of August, applying for authorization in terms of Section 2.4 on that same date. Now, when you look at the contents of Advocate Maema's letter to Advocate Jiba, who had been asked to issue the racketeering certificate by Advocate Noko, you see in the contents of that letter, Advocate Maema had declined to prosecute in that matter. If you look at paragraph 9,
Advocate Smith, Madam Chairperson.
pardon?
It says the Director of Public Prosecutions, Northwest, and when Advocate Maema was a deputy, not a director.
Yes, you are correct. It was Advocate Smith who had declined to prosecute in this Rustenburg matter.
That is correct.
They had instructed an inquest, that is the paragraph 9. Now when you go to paragraph 10, or rather paragraph 12, now the prosecution team prefers the following charges in respect of the Rustenburg dockets. They are making that decision, the prosecution team. And at 13, it says it is desirable and in the interest of justice that all the matters be held in one forum. This is Advocate Chauke, following what Advocate Noko had done on the same day, 15th August, to Advocate Jiba, requesting for authorization or issuance of the authorization certificate. And there is a memorandum there which is undated. Maybe I should just check with Advocate Maema. There's a memorandum at LO 00808.
That is correct, Chair.
There is no date to this memorandum. And this memorandum was prepared by yourself as the Director of Public Prosecution or Deputy Director of Public Prosecution. I suppose it refers to your position as you deputized Advocate Smith in the Northwest.
Chairperson, when I sign as deputizing Advocate Smith, I would specifically refer to the Northwest. But here I refer to the NPS.
And
So NPS is the National Prosecuting Service, which is head office. So here I'm signing as a Deputy Director of Prosecutions in the NPS, in the capacity that is delegated to me by Advocate Jiba.
by Advocate Jiba.
That is correct, yes.
There is no date to this prosecution memorandum. When was it?
Chairperson, the prosecution memo together with the covering sheet, it is one document. We prepared on the 15th of August, 2012.
Are you saying that that prosecution memo was attached by Advocate Noko to the application for the issuance of the racketeering certificate?
Oh, that is correct, Chairperson.
This is on the 15th of August.
15th of August, 2012.
And we know now in that letter of the same day by Advocate Chauke, indication is that the Director of Public Prosecution, Northwest, had declined to prosecute this Rustenburg docket.
That is correct.
Towards the end of this memo, your team indicates that they prefers the following charges in respect of that docket,
That is
the
correct, Chair.
Rustenburg docket.
Yes.
And they say at paragraph 13 that it is desirable that it will be in the interest of justice that all these matters, including the Rustenburg one, I suppose, be held in one forum.
In one forum, yes. That is correct.
And they explain at 13.1, the separation of the trial forums will lose their similar fact evidence. Correct?
That is correct, Chairperson.
13.2, all the accused are based in KZN or KwaZulu-Natal, therefore centralization will be cost effective.
That is correct, Chair.
Efficient, rather. 13.3, the offences in Rustenburg were furthering the aims and objectives of the enterprise operating in KwaZulu-Natal. It is thus prudent for proper functioning of the administration of justice that these offences are tried together in a single trial.
That is correct, Chairperson.
13.4, the motive for the killing is closely connected to the other killings in KwaZulu-Natal. The chain of the killings, as well as the modus operandi, will provide the court with a complete picture of the manner the enterprise operated.
That is correct, Chairperson.
14. In the light of the above, separate trials will be prejudicial to the accused, witnesses, and proper administration of justice.
That is correct, Chairperson.
And those documents at paragraph 15 were attached.
That is correct, Chairperson.
16. Although Boysens and Olivier were not present on the crime scenes in Rustenburg, they have been added in this application by virtue of their management of the activities of the enterprise.
That is correct, Chairperson.
Advocate Chauke then signs
Yes,
the
Chairperson.
document.
Yes.
I refer to the content of this letter because counsel seems to focus on the headings that correctly reflects that it is Advocate Chauke who wrote to Advocate Jiba,
Yes, Chairperson.
and that cannot be denied.
Yes.
Yes, thank you.
As a follow-up, Advocate Mtsweni, I understood that you were going to ask clarity-seeking questions.
Yes.
And clarity-seeking questions based on Advocate Maema's evidence,
As well as the evidence that he has not covered.
as well as the evidence that he has not covered. But I will concentrate on the evidence that he has covered. It would be appreciated if when we put statements to witnesses, we put them in the correct context, or we refer to what they have already testified about and juxtapose it with what we have in front of us. And I'm saying this because if my memory serves me well, Advocate Maema explained the operations within the NPA, how he as a team leader, prosecutorial team leader, communicated with the NDPP. And one of the examples that come to mind is a letter that was written on the letterhead of the KZN office, and then with Advocate Nuku's name, and then signed, I think, PP'd by Advocate Chauke. And he explained that he does not have a direct line of communication with the NDPP. I would have thought, maybe that's me, that once he says, I'm the author, the next question would have been, and I think that's what my sister has been trying to say, that the witness answers, this is, I'm the author of this document. Then the next witness would be, then how come we see Advocate Chauke's name and and his signature, and give the witness an opportunity to explain that he might give a different explanation than what he gave the previous time, which would show inconsistencies and contradictions, or it might confirm what he said. And I thought that would be the purpose of the clarity-seeking questions.
I appreciate it, Madam Mayor. I think I take note of that and will apply that.
You're going to go to the next topic. I suppose this is the topic where you are on centralization. Now, from the point you made that the letter of the 15th of August 2012 by Advocate Chauke, which he signed to Advocate Jiba, is the proposition, and I must not go ahead of you. What is the proposition with regard to that point?
The proposition was Advocate Chauke equally empowered to make such application or not?
Pardon?
Was whether Advocate Chauke was empowered to make that application or not. That's what I wanted to find out from the witness.
You understood the question now by Advocate Mtsweni?
That is correct, Chairperson.
Would you please answer?
The answer is, it is me who is asking Advocate Jiba to approve the centralization. Me, in my capacity as deputy, because now I'm in Advocate Chauke's office, I communicate through him, as I do not have direct first-hand communication line with the National Director. So the mere signing by Advocate Chauke is to give it efficacy, because it is the DPP who communicates with the National Director, not the deputy.
Yes, thank you, Advocate Maema. Are there more questions from the panel before I proceed, Madam Chair?
Give me a second, I'm just writing his...
Okay.
answer. Will that still be the case, given that you wrote the prosecution memo and whilst you were wearing the hat as the Deputy Director of Public Prosecutions, National Prosecution Service?
Chairperson, it is still the same. It's in my capacity as a deputy, and then when I communicate in that capacity, I communicate through the DPP. If, Chairperson, I would have been deputy in NPS at head office, it would be different. But because I'm a deputy in the office of the DPP, then I communicate through the DPP. Effectively, what I mean is, if I would be at national office at that stage, then there wouldn't be a need to communicate through a DPP, because at national office there are no DPPs. So a deputy NPS would be able to communicate directly to the NDPP. But because you are a deputy, even if you are a deputy NPS, if you are in the office of the DPP, that communication has to go through the DPP.
Yes, thank you.
Madam Chair, I've been envying advocating with Toby every time he says, perhaps it's time for the tea break. Been wanting to say those words. So would it be appropriate that we take the tea adjournment now?
My sister has just nudged me that somebody must have looked at her to say tea time. It is indeed tea time, and we will adjourn until 12:15. Remember, you are still under oath, Advocate Maema.
That is correct, Chair.
Thank you. Good day, everyone. Advocate Maema.
Good day, Chairperson.
Advocate Chauke. You are still under oath.
That is correct, Chairperson.
You may proceed, Advocate Mtsweni.
Thank you, Madam Chair. Advocate Maema, you have explained to us that, in fact, the application for centralization dated 15 August 2012 was made by you. All that Advocate Chauke did was being a conduit. Yeah.
That is correct, Chairperson.
Right? But now, if you go to 856, are you there?
Page 856.
Yes, LO 00856.
The bundle is a legal opinion 3 of 4. Mr. Marani, please assist the witness. Mr. Marani, please get the volume for the witness.
Not here.
Legal opinion 3 of 4.
No, is it this one? Oh, 806. Oh, okay. That is correct, Chairperson. I'm at 806.
That is a similar application for centralization of the Rustenburg case 10909-2009. Do you see that?
NJ3.
Yes. Do you see that?
I see that, yes.
And the wording is the same, except at the end of that document at 859.
Please just refer us to the pages as reflected in that volume.
Thank you, Madam Chair. I then, Adv Maema.
I'm there, Chairperson.
Yes. But then, on LO 859, the signature is yours,
That is correct, Chair.
and it says PP.
Yes.
And when one goes to LO 856,
I'm there, Chairperson.
the application
LO
LO 856, Madam Chair.
856.
The application is now made in the name of Advocate Noko, the then acting Director of Public Prosecutions, KZN. Do you see that?
I can see that, Chairperson.
And you can read it word for word. The wording is the same as the previous, the one dated 15th August.
And this one is dated
20th August.
Oh, yes, I see that, yes.
Yes. Now, the fact that you now decided to make the application in Advocate Noko's name, could that be an acceptance that that application should not and could not have been made in under Advocate Chauke's name?
Well, I agree with you. What we did, we realized that even irrespective of us being based in the DPP South Gauteng, the application has to be made from from the office of Advocate Nuku.
Yes. And you had Advocate Nuku's contacts, am I correct?
Yes, I did.
So you had a direct line to her.
Yes.
And even Advocate Simpiom Locho.
No.
So you never had his numbers.
No, I never had his number.
Yes, but then after Advocate Nuku became the acting DPP, you had direct access, you had a direct line to her.
Yes, I had her numbers.
You had an email as well.
That is correct.
Yes. Now, the question then is, and you now consider that this application resorted under Advocate Nuku's jurisdiction because the matter was sought to be prosecuted in her jurisdiction.
That is correct.
And that in terms of section 24(1), she's got the power to do this application,
That is correct.
not Advocate Chauke.
That is correct.
Now, with this realization in mind, why didn't you make similar applications and communications to the NDPP through Advocate Nuku? Because you had a direct line. She was aware that you were the prosecution team. She was aware of your existence.
Chairperson, what I'm saying was on the 15th of August, when we made it under the letterhead of the DPP South Gauteng, and we used Advocate Chauke to communicate that request. We were simply in the office, in his office. But on the 20th of August, we were working from the office of Advocate Nuku.
Yes, but at that time you had already been granted the centralization authorization on the 17th.
The centralization was already granted, yes.
Yes, and yet you make another one.
On the 20th.
Yes, on top of, because you understood that it was improperly made. It should have been made under Advocate Nuku's name.
It was to regularize.
Exactly. Now, and you then signed on behalf of Advocate Nuku.
That is correct.
Yes. On the 15th
Of August
yes,
2012.
yes, an application for authorization in terms of Section 24 was made to Advocate Jiba. Do you recall that?
That is correct.
And that was preceded by, and it was made in the name of Advocate Nuku. You can go to LO 00780. LO 00780.
I am there, Chair.
That is an application that was made for poker authorization under Advocate Nuku's name. Do you see that?
That is correct, Chair.
And it is signed by Advocate Chauke.
It is signed PP by Advocate Chauke, yes.
Yes. And you testified that the signing of that document on behalf by Advocate Chauke, on behalf of Advocate Nuku, was based on an arrangement. Do you recall that?
That is correct, yes.
And you testified two things. You said, one, you had made that arrangement with Advocate Nuku yourself.
That is correct, yes.
And you also said that there was an arrangement between Advocate Nuku and Advocate Chauke that he will sign.
That is correct.
Now, I take it that you were not part of the discussion between Advocate Chauke and Nuku when that arrangement was made.
That is correct, yes.
And you therefore got knowledge of that arrangement from Advocate Chauke?
No, from Advocate Noko,
Yeah, well,
because she is the one that I communicated with.
yes. You know, the reason I'm asking you this, Advocate Noko denied, she was here sitting the way you are. She denied knowledge of this document, and as well as that there was any arrangement made with her that that application will be made in her name.
Chairperson, this incident happened in more than 10 years ago. So I wouldn't know if she would have forgotten about it.
No. She was adamant, in fact, that she knew nothing about this document. She was never consulted. She never authorized anyone to sign on her behalf.
I communicated with her, and that arrangement was made.
So
I remember that.
Now, based on that, you'd agree that the version that you are giving us today and the version that Advocate Noko gave sitting in the same chair are two different versions.
Yeah, I hear her version from you, but
No, you can accept that.
I do.
If it was not, I'm sure that would have been corrected by now.
Yes.
So now, there being two versions before this panel, one saying, I know nothing about this document, I've never made any arrangement with anyone to sign on my behalf or submit this application in my name, and then you, in the same chair, through the same, saying that there was an arrangement with Advocate Noko. These two versions are not consistent with one another. You agree with me?
I agree with you, Chairperson.
And therefore, meaning that one of you is not telling the truth.
One of us could be making a mistake.
Yes, but remember, it's under oath.
Yes, but what I'm saying is, I remember I made this arrangement.
So if we accept your version, then it means that Advocate Nogo's version is not the truth.
It's a possibility that she's making a mistake.
Now, I recall, and I can take you there, during your examination in chief, Advocate Toby, when you were discussing the document titled Monetary Awards, made the following, where he said that if someone makes a false statement under oath, what does that mean? Do you recall that?
Yes, I do.
What was your answer?
My answer was that person commits an offense.
What offense is that?
It's an offense of perjury.
Yes. So therefore, can we say that either you or Advocate Noko is doing the same thing?
Chairperson, perjury is with the intention to deceive. I would doubt if Advocate Noko or myself would have that intention to deceive. That is why my submission is, I submit she's making a mistake.
Yes. Okay.
Because of the lapse of time when these things happened, and now it's only now that we're dealing with them.
In fact,
A human mind is fallible.
But I can assure you she was adamant as you are.
Oh, yes. Okay.
Yeah. Now, we'll skip and move forward. We know that in 2014, in February, on the 23rd, the Gauteng judgment was handed down.
That is correct, Chairperson.
And at that time, Advocate Mtsweni, Mr. Mtsweni, was now the new national director.
That is correct, Chairperson.
Yes. And now, at that time, I remember during your evidence when you started, Advocate Toby was very happy to refer you to your authorization, which, amongst others, gave you the power to appeal to any judgment or to prosecute any appeal against any review of whatever decision that comes out of your decisions to prosecute in the Cato manner. Do you recall that?
You're referring to the fact that The authorization authorizes the prosecution as well as the any subsequent proceedings, appeal review?
Yes.
Yes, yes.
Yes. And now, you were not in court when that judgment was, when the matter was argued. That was your version,
That is correct, yes.
right? You then you were not happy with the judgment as the prosecution team.
We are not happy with the outcome of the judgment. Yes.
Yes. But nonetheless, okay, but before we move, before we get there, I just want to stick to August 2012 because what I'm going to deal with is still in 2012.
I follow, Chairperson.
On the 14th, you circulated Advocate Mtsweni,
14th of what?
August 2012, Madam Chair. In fact, you can go to the annexure to your statement, and that would be page A, 1A785.
I'm there, Chairperson.
Right?
Okay.
7. In fact, it starts, I'm going to start at the bottom at 786.
I thought you said 1A175.
Yeah, no, 78. 1A785. But go to 786 because there's a trail of emails.
I am at 1A786.
Yes.
Can you refer us to the number of the exhibit? It's GSM something, I think. Is it not?
GSM 778. Now, but before I start, just before I forget, Advocate Maema, let me just wait for the chairperson to come to recompose.
Yes, Council?
You testified that there was a procedure that you cannot communicate directly with the national director as a deputy.
I'm not saying there was a procedure. I said we ordinarily do not communicate directly as deputies to the national director.
But there was no document that strictly prohibited that.
No.
Okay.
Just out of protocol, deputies communicate through DPPs.
Now, are you at 1A786?
Yes, I'm there, Chairperson.
And then the heading is, it's an email from Advocate Mtsweni, dated 14 August 2012, to Mahlubin Tlagaza and yourself, and the subject is final Cato Manor indictment as modified by Advocate K.R. Matenja.
That is correct, Chairperson.
And it says, colleagues, here with more corrections to the summary of facts and memorandum regards. Do you see that?
That is correct, Chairperson.
And then on 1A785,
I'm there, Chairperson.
on the following day, Advocate Ntlakaza says, these are minor changes on enterprise only. I think this we can get our certificates. I'm not sure whether Advocate Maema has printed hard copies. I'll be at the Constitutional Court today. Do you see that?
I see that, Chairperson.
Yes. And then you then respond midday on the same day.
I beg your pardon, why do you say on the following day or on the next page?
Yeah, it's going up, Madam Chair.
Yes.
Yes, because the email from Tlakaza was on the 14th. You see at the bottom of 785.
But you have the one on top from Masubi Ntlagasa, 15 August 2012?
Yes, no, I'm saying below that there's the person who circulated that email was Mosing
Yes, on the 14th.
on the 14th.
Yes.
Yes. And you then respond on the same day, at midday, just after midday, to Advocate Mosing and Matenja, and then you then at the second last paragraph, the last sentence says, I have also done the prosecution memo on KZN letterhead, although our DPP will sign as arranged with the acting DPP KZN. Do you see that?
That is, I see that.
We've already dealt with that aspect. But what I'm interested in is that if you move up to 784, 1A784,
I am there, Chairperson.
right? You, at 2 p.m. on the same day, you write to Anthony Mosing, and this time you write to him alone. Do you see that? You don't copy other members. Where it says Adv Maema GS 15 August 2012 02:37 p.m.
I see that.
Yes.
M78.
Yes.
If you can refer to those
Okay.
annexes.
You at that email, in that email, at the last sentence, second last sentence says, I will send you the corrected version of all the documents. The DPP secretary is still looking at the spacing, aligning, etc. Do you see that?
I see that.
Meaning that this document was on Advocate Chauke's secretary's computer.
No, it was never on her.
No, you say the DPP secretary. Who's the DPP secretary?
That's Mamiki.
Yes. And you say the DPP secretary is still looking at the spacing, aligning, etc.
Yes, what we do is to finalize the document, as it would be on my computer. We'll just call her to the boardroom, and she will correct it on my computer.
Now let's go up to what Advocate Mosing says to you at 0307. Do you see that?
I see that.
I have just received the document sent by the DPP for authorization.
Yes.
Remember, you had said that you are a very experienced prosecutorial team that does not need supervision or any inputs from the DPP.
Yes.
And yet you talk about you've received documents sent by the DPP for authorization, meaning that Advocate Chauke had an input in your documents.
No, it doesn't say he had an input.
But why would he send them to you if he did not have an input?
No, remember that the documents are between myself and Advocate Mosing.
Yes, you say to Advocate Mosing, I just received the documents sent by the DPP.
So,
Meaning that the documents that you say you've received were sent to you by the DPP.
no, the documents were sent to Advocate Mosing by the DPP.
Yes, that's what he says.
Yes.
Yes. Now, why, if Advocate Chauke had no role to play or input, why would your document be sent by him to you? When I say to you, the prosecution team, in this case, Advocate Mosing.
No, remember, Advocate Mosing is not part of the prosecution team.
Is that so?
Yes, he's not.
Okay.
He is at head office.
Oh.
Now, what are you doing? Remember I said communication from prosecutors go through the DPP.
Yes.
Yeah. So
Now-
communication from the prosecution team would happen through Advocate Chauke's office.
Yes. But let's look at what Advocate Mtsweni then says.
Yeah.
We must just make sure that the DPP is happy.
I see that.
Now, if Advocate Chauke had no input whatsoever, why would his happiness be of concern to Advocate Mtsweni?
Well,
Because he's merely a conduit on the version that you've given us.
no, but it says the DPP. It doesn't say Advocate Chauke.
But remember, you said the DPP in question, that you when it was Advocate Chauke.
No. When Advocate Mtsweni talks about the DPP being happy with what? With the indictment.
Yes.
So
now, we remember, Advocate Mtsweni is based at the national office,
yes,
and there are no DPPs at the national office.
yes.
Now, therefore, it's either he could refer to Advocate Noko or Advocate Chauke,
To the former,
right?
because the former is the one from which the racketeering request has to come from.
Yes, but we know that that document did not come from Advocate Noko. It came from Advocate Chauke, because you submitted it through Advocate Chauke.
Because of the arrangement that was made for Advocate Chauke to sign the communication. Remember I said communication from DPP to NDPP? So it's a communication from Advocate Chauke from a DPP, who then was Advocate Chauke because we were in his office,
Yes.
the National Director.
And that's the DPP that Advocate Mtsweni is talking about.
No, when Advocate Mtsweni says happy with the documents, it means happy with the indictment and happy with the prosecution memo.
Yes, but I'm talking about who must be happy.
Advocate Noko.
But Advocate Noko told us that she knew nothing about those documents.
No, Chairperson, I traveled specifically to KZN to go and discuss this prosecution memo and indictment with her.
Yes. Now, okay, we will leave it there, but I think Advocate Mtsweni, we were told, is going to come and he will explain as to who did he refer to as, whose happiness was he concerned about.
Yes.
Yes.
And the evidence, what you're putting to the witness is that the DPP there at the email of 15 August 2012 at 3 p.m. refers to Advocate Noko, according to you.
No, according to the witness. But according to
to
us,
the witness.
what we say, if one looks at the text of the email, starting from his email, from Advocate Maema's email of 237, where he said the DPP secretary, he was referring to Advocate Chauke's secretary. Now, the point is that any reference to the DPP referred to Advocate Chauke in that email. It was referring to Advocate Chauke.
Did you put this proposition to Advocate Noko when she testified?
Madam Chair, we could not put it because she denied any knowledge or involvement in the documents. She said
You did not put it
no, we
to
did
her.
not put it to because she said she knew nothing about the documents. She was never consulted. She never authorized anyone to sign on her behalf.
But there's a document. You should have put it to her.
No, but Madam Chair, if a witness says, I don't know this document,
She said she didn't know this email.
remember, Madam Chair, the document that is being spoken about here is the poker authorization.
Yeah.
And Advocate Nuku was asked about this poker authorization that I asked dated 15 August. And she said she didn't know anything about it. The first time she saw it was at the state capture. And I even asked her that the record reflects that there was an arrangement that Advocate Chauke will sign on your behalf. She said she did not authorize Advocate Chauke to sign on her behalf.
I hear what you are saying. I'm asking you now that you are now dealing with this very document, which is part
No,
of.
we never put that document
You
to
never
her.
put it to her.
No.
That's what I was asking.
Yes. Thank you, Madam Chair. Now, Advocate Maema, we are now back at post-Gorven judgment,
Yes, Chairperson.
right? After the Gorven judgment was handed down on the 5th of March 2014, do you recall that?
I recall the
GSM 82, Madam Chair. I've made the document, the GSM 82. No, it's not March, it's 26 February 2014,
February.
82.
82. And you earlier on referred the witness to that judgment, and then
Then
you
I,
asked whether he was happy with the judgment, and he said we were not happy with the outcome. Going back there?
yes, I'm going back there, Madam Chair.
Yes, M82 is a what? 1A?
18799, Madam Ramakha.
Is GSM?
82.
Better to refer to GSM because some of the 1A are not legible because of the numbers written on top of those numbers. So you can refer us to 1A, whatever, if you have it, and then refer us to the GSM annexure.
Yes, I've did, Madam Chair, said GSM 82.
Sometimes I can't see. Is GSM what?
82.
GSM.
The memorandum,
Yes,
not the judgment.
yes.
What are you saying now?
I'm saying to Advocate Maema that
No. You referred us to the judgment, which you.
I said the Gorven judgment was handed down on the 26th of February.
So GSM 2 is not a judgment.
No, it's not the judgment, it's the memorandum by the prosecution team.
See, that's why I get confused.
Advocate Mtsweni, would that tie with something that you left hanging up there about the appointment of Mr. Ngasa?
Yes. I was just going to come and clarify, just put it together because I left that point. I recall that I made mention of Advocate.
Remember, we are writing manuscripts, so you can't go back and
Apologies. Okay, Mr. Maema, let's just put everything into context. Advocate Ngasana was appointed, I think, in 2013. Am I correct?
That is correct.
And after his appointment in 2014, February to 26 February 2014, the Gorven judgment was handed down.
That is correct.
Yes. And as the prosecution team, remember you are the repository of the power to appeal or not.
That is correct.
Yes. And that power has not been withdrawn.
100%.
Yes. So therefore, you had been, even after Advocate Mr. Ngasana came into power, he never withdrew or amended your authorizations to withdraw the power to file appeals.
That is correct, Chairperson.
Yes. And then aware and alive of that power, you then penned a memo dated 5th March 2014. That is GSM 82
Yes,
1A799.
that is correct.
Yes. The memo is addressed to Advocate Chauke, and it's from the National Prosecuting Team. Am I correct?
That is correct.
But the purpose of that memorandum at paragraph 1, you say the purpose of this memorandum is to update the National Director of Public Prosecution, NDPP, and the head of NPS following the judgment delivered by Gauteng J of the KwaZulu-Natal High Court on 26 February 2014. Is that correct?
That is correct.
Yes. And at paragraph 421, that would be of your statement. That would be 1-116, page 1-116.
I'm there, Chairperson.
Are you there, Madam Chair?
Yes, I got it. Thank you.
You say to us, given that Mr. Ngasana was newly appointed, the prosecution team prepared a memorandum dated 5th March 2014 in order to enable Advocate Chauke to brief the NDPP. Do you see that?
I see that, Chairperson.
And if we zoom in into your memorandum at paragraph 11, that is 1A801, still on Annexure GSM 82.
Memorandum GSM 82, paragraph.
Paragraph 11.
Yes.
You say, in terms of the process, since we do not intend to appeal the judgment, we are of the view that we should call upon the applicant to appear before the High Court to formally withdraw the charges in the meantime, pending an intended application to you, sir, for new authorization. Do you see that?
I see that, Chairperson.
And that's what you guys wrote.
That is correct.
And you took the decision not to appeal, alive to the fact that that power lies with you.
That is correct.
Yes. And you're telling him that what you intend doing is to apply for new authorizations.
That is correct.
And you even use the word sir with a capital letter.
That is correct because it refers to the National Director being a male at the time.
And showing respect.
Well, you're always respectful to
Yes.
our seniors.
And then at paragraph 12, you then say the prosecution team intends to apply to the NDPP for the reissuing of the certificates. We shall prepare a new memorandum which outlines in detail the evidence against the applicant. And then 13, we still firmly... Excuse me, Madam Chair, my device decided to give up on me.
Please come and help Advocate Mtsweni.
No, I've got the document. Whilst it's still restarting.
Let our
It's fine.
lady there
It's charging.
to assist you with the connection.
No, it's charging, Madam Chair. It's gonna, yes. I just lost. I'm back, Advocate Maema. You, at paragraph 13, you say, we are still firmly of a strong view that there are sufficient facts which justify the reissuing of racketeering authorizations. Is that correct?
That is correct, Chairperson.
And at the time that you penned this memorandum, I did my calculation, the judgment was 5 days old.
Please repeat yourself.
The
Judgment was?
5 days old,
Was 5 days old.
yes. 5 court days old. Do you accept that, Mr. Maema? You
I accept your
Yes.
summation, Chairperson.
And the main purpose, as you told us, was so that Advocate Chauke can go and communicate your decision to Mr. Ngasana.
That is correct.
Yes. Now, in your at paragraph 21, you tell us that given that Mr. Ngasana was newly appointed to prosecution team with Red Dead, and then we advised Advocate Chauke that based on the concession made by Horace SC, the team's view was that the judgment should not be appealed against, given that the court did not foreclose the door on the NPA to reissue the poker certificates. Do you see that on your statement?
That is correct.
So therefore, you had made it unequivocally clear to Advocate Chauke that as the repository of the power to appeal or not, we are not going to appeal.
Before the witness answers, Advocate Mtsweni, you must help us. You read from different documents. Now you've just read from the witness statement. You don't even take us to the paragraph.
Sorry, Madam Chair, I thought
It makes it so difficult.
I apologize. Okay, let's just run through this thing slowly. Remember at paragraph 421, you told us what was the purpose of the memorandum, that it was to enable Advocate Chauke to go and brief Advocate Ngasana on your decision and what cause you intended what cause you intended adopting.
That is correct.
Yes. But then on the same paragraph you said, the third line, you said, we advised Advocate Chauke that based on the alleged concessions made by Hodes SC, the team's view was that the judgment should not be appealed, given that the court did not foreclose the door on the NPA to reissue the poker certificate. That would be that paragraph went over to page 117, 1-117. Do you see that?
I see that.
So basically, Advocate Chauke knew as of the 5th of March 2012 that the prosecution team, being who've got the power to prosecute, do not intend appealing the judgment.
That is correct.
Yes. Now, what is surprising, on 117, right, you, at 422, paragraph 422, you said the prosecution team consulted with Hodes SC with regard to the concession referred to in the judgment, and on the 13th March 2014. Do you see that?
I see that, Chairperson.
Yes. But this is despite the fact that you said, listen, yes, there was this concession, but it is immaterial. Because despite this concession, we do not intend appealing. Is that correct?
Not with regard to the concession. We are not appealing about the concession. He said he was not satisfied with the conclusion, the outcome of the judgment. Now you are referring to the concession. You say the appeal about the concession. Would you please rephrase the question?
Okay, may I just preface it, Madam Chair, so
Yes,
that my
I think
question...
you can rephrase it.
Yes. Advocate Maema, so that I'm not misquoted. If we can just go back.
No, you are not going to be misquoted. You are confusing us with the way you put your question.
Yes, I just want to so that everything flows, Madam
You
Chair.
are misquoting.
Yeah, I apologize, Madam Chair. At 1A801, we're back on GSM 82. All right? That is your memorandum. 801. Let me just start at paragraph 10. You say, we feel, therefore, that the concessions were incorrectly made. This aspect which
You go out of the view. You can't feel. It's
No,
a view that you have.
No, he does what is written there, Madam Chair.
Where?
Paragraph 10,
Are you reading from
GSM 82.
1A, GSM 82
Yes, at 1A801.
at 1A 801?
Yes. That is the prosecution memorandum, the
Yes.
memorandum from the prosecution.
Paragraph 10.
Yes.
Yes.
You say, we feel, therefore, that the concessions were incorrectly made. This is the aspect which informs us that it is undesirable to appeal this matter. Do you see that?
I see the Chairperson.
Yes, meaning that in as much as you are unhappy with the concessions, you still not intend, you still don't want to appeal the judgment.
In so much as we're not happy with the outcome.
Yes, you still don't want to appeal the judgment.
Yes.
And that, when we go to paragraph 4, back to paragraph 421 of your statement at 1-116, you state there that we advised Advocate Chauke that based on the alleged concession made by Holders SC, the team's view was that the judgment should not be appealed, given that the court did not foreclose the door on the NPA to reissue the poker certificates.
That is correct, Chairperson.
So meaning that Advocate Chauke knew that irrespective of how you feel as the prosecution team of the concession, you still don't intend appealing the judgment.
Well, irrespective of how we feel about the concessions, we still hold the view that we are not appealing the
Yes.
judgment.
And you say that you advised Advocate Chauke.
We briefed him.
Yes.
We
So,
informed him. Yes.
so he knew.
Your word is that you advised him. I think you can go back to 421.
Yes.
The counsel is correct. You advised Advocate Chauke.
We advised yes on 421. That's
Yes. Now, what is then surprising, Mr. Maema, is that paragraph 422 at -1117, your statement, you then tell us that on the 13th March 2014, you held a consultation with Advocate Holders SC, and that consultation regarded the concession referred to in the judgment. Do you see that?
I see that.
Yes. So despite the fact that you felt that in as much as the prosecution team is not happy with the concession, we do not appeal against that, you find yourself in a consultation with Advocate Holders SC regarding the same concession.
That is correct.
Yes. And remember, you had all penned that memorandum so that Advocate Chauke can go and brief Advocate Mr. Ngasana of your position.
That is correct.
And we do not hear from your statement that that briefing took place.
Which
The briefing by Advocate Ngasana, by Advocate Chauke to Mr. Ngasana. You do not tell us that Advocate Chauke did go and brief Advocate Mr. Ngasana.
yes, I do not talk about it as it is not. Remember, it is he who then consulted with Mr. Masai.
Yes. But between the 5th of March,
Yes.
being the date of your memorandum, and the 13th of March, being the date on which you find yourself in consultation with Advocate Holders
SC,
that briefing had not taken place.
The briefing by?
Advocate Chauke to Mr. Ngasana.
I do not know whether it had taken place or not.
Yes. Let me tell you why I'm saying it did not take place. On paragraph 423, no, in fact, let's go to 424. Of your statement.
I'm there, Chairperson.
You then tell us that shortly thereafter, I'll come and tie it up very shortly. Mr. Ngasana issued an instruction that the application for leave to appeal must be withdrawn. Do you see that?
I see that, Chairperson.
Yes. So basically, Advocate Ngasana, Mr. Ngasana, agreed with your stance that you should not appeal. That's why he issued an instruction that the leave to appeal should be withdrawn.
That is correct.
Yes. And therefore, but now what happens is, on the 13th of March 2014, you found yourself at the consultation with Advocate Hodes SC. And at that consultation, the following happens. A decision is taken despite you having made your position clear that you do not intend appealing this judgment. A decision is taken that you must file an application for leave to appeal.
Remember, when we filed the application for leave to appeal, it is precisely just to deal with the DS indicia, to prevent the filing of a condonation
But
application.
on the 5th of March, you had said it's not necessary. We're not going that route. So why should you be concerned about the DS indicia? Because you, as the repository of the power, had said we're not appealing.
Yes, but remember, in a high-profile matter, when we update the national director, at that stage we did not know on which side of the fence he would be. So
Yes.
rather to be safe, you file a notice of appeal, that you know that if he agrees with us, we can simply withdraw.
Yes. And therefore, meaning that at that time on the 13th, when the prosecution team found itself consulting with Advocate Hodes SC,
Yes.
you still did not know what Mr. Ngasana's stance was.
That is correct.
And Advocate Chauke was present in that consultation.
That is correct.
And as the person whom you had tasked to go and brief Advocate Ngasana, had he consulted with Mr. Ngasana, he would have told you that I've briefed Mr. Ngasana and this is his stance. He did not do so.
Well, yes, he did not do so.
So therefore we can accept that as on the 13th of March, Mr. Chauke had not briefed Mr. Ngasana.
I cannot say that because he did not say that.
Yes. But now let's look at what you say Advocate Chauke said in that meeting. In that meeting, after...
Sorry, before you move to that, I'd like to ask just one point of clarity from Advocate Maema.
Yes, Chairperson.
As at the 5th of March 2014, when you penned the memorandum advising that you're not going to appeal because the judgment did not close the door on the NPA in terms of the racketeering authorization certificate.
Yes, Chairperson.
Did you know the reason why the concessions were made by Hodes SC?
We did not know at that stage.
Well, just a follow-up on that question. Is it untoward to consult with Hodes SC to find out why he made those concessions that may have compromised the NPA case?
Chairperson, can you repeat the question?
Is it out of character? Is it untoward? Is it
No, Chairperson, I follow now.
abnormal
Yes,
for you to meet with Hodes SC to get an explanation on why he made those concessions which might have compromised the NPA case?
Chairperson, it was in order, it was appropriate that we bring that to a logical conclusion by understanding from Advocate Hodes' self how and what led to the concessions being made.
Yes. But now, you said at that meeting, he told you he never made those concessions.
No, I didn't say that. I said he didn't say anything about, you're saying, no.
At the meeting of the 13th of March,
Who
you
did
say, how does SC advise that he did not make a concession referred to in the judgment?
Yes, how does SC says he didn't make it?
So now, but the point of the matter remains that whether the concession is made or not, you felt on the 5th of March that it is not necessary to appeal the judgment.
That
You have to look at the sequence of events, look at the date, Advocate Mtsweni. Look at the 421. When he advised Advocate Chauke that the team was of the view that they would not appeal. 422, they meet Advocate Hodes, that is on the 13th of March, and he, Senior Counsel Hodes, advised that he did not make the concession.
Yes.
On the 13th.
Yes.
That is following the
Consultation.
the view that they had presented to Advocate Chauke.
Yes.
Now go to 423.
Yes.
Now following.
Oh,
You
you
want
can
to-
you can continue, Madam Chair.
You
Sorry.
may.
No, now, Mr. Maema, when I read your statement, one thing that I picked up was that you did not have a direct line to Advocate Hodes SC. Am I correct?
no, with the instructed counsel, we are communicating through Advocate Chauke as well.
Yes. But you see, what is also missing in your statement is how and at whose instance was the consultation with Advocate Hodes SC arranged? Would I be correct that the consultation was arranged by Advocate Chauke?
I cannot remember who arranged it, but when we had the outcome of the matter, we were not happy.
Yeah.
We were not happy.
I'm talking about the consultation.
So ordinarily, we would have informed Advocate Chauke, who then we would have requested him to arrange that we meet with Advocate Hodes.
But in this case, you do not tell us that you requested Advocate Chauke to arrange that consultation.
No, I do not. Yes.
So the fact that you do not say that means that you did not arrange it. You did not request it.
No.
You never requested the consultation.
And I'm saying the fact that I did not say it does not mean we did not ask Advocate Chauke to arrange a meeting for us.
So are you saying that the consultation was requested at your instance, at the prosecution?
It should have happened at our instance, yes.
Yes. Now, when you asking him to arrange the consultation, did you ask him whether he had briefed Mr. Ngasana as per your request? When you asked Advocate Chauke to arrange the consultation with Advocate Hodes SC, did you also ask him if he had briefed Mr. Ngasana?
I follow now. No.
You never asked.
No, we didn't ask.
But what we know is that it became clear at the consultation that the NDPP had not yet taken a decision, a position on whether or not to appeal.
That is correct, yes.
Yes. And for that reason, you were persuaded to change your mind as the prosecution team to file an application for leave to appeal.
Now, remember, the leave to appeal, it is not a matter of persuasion. The only filing of the leave to appeal was to prevent the DS and DKI from running.
Yes. But
in case the national director were to...
You must wait.
Okay, sorry.
And let the witness finish.
In case the national director were to say, I think your initial decision to appeal was correct, then you don't have to file a condonation application.
But you'd agree with me that the fact that the DS have run past does not close the door from you filing the application.
Of course it doesn't, but you will require to file a condonation, isn't it?
Yes.
Yes.
And it is for the court, not Mr. Ngasana or the prosecution team to determine whether good cause has been shown for the condonation to be granted.
They must show it.
No, but I'm saying whether it has been shown.
They
They-
must first show it for somebody to decide whether such cause has been shown.
Yes.
And he testified yesterday that to obviate that, they decided to then file a notice of appeal. You remember?
Yes.
That is why
Okay.
the question of DS non was raised.
Oh, yes. Okay, now thank you, Madam Chair, for the
Yes.
clarification.
But
Okay.
I was going to ask you the question, and you interrupted me and then allowed you to proceed.
Sorry, madam.
Because I see Advocate Mtsweni, you start questions and you leave them hanging. So I said, let's start from 2421 and look at those paragraphs in sequence and look at the dates. 421, it deals with the advice, expressing an intention not to appeal. At that stage, there was the alleged concession.
That's correct, Madam Chair.
422, there is a consultation with the senior counsel. Yes, as you are looking at the time, we still have a lot of time.
No, Madam Chair. Mr. Ngaido promised me something if I finish in an hour. So I'm trying to see if I'm still within that hour.
He's not in charge. You must ask us. We are in charge, and we'll give you as much time as you require, counsel.
Thank you, Madam Chair.
Yes.
So I lost
Now-
out on the wager that Mr. Ngaido had put up.
You can waive his offer. At 422, they consulted with the senior counsel holders, and that is on the 13th, where he advised them that he did not make a concession. Now look at 423. They are now considering their position. Following what Advocate Holders has told them, they are considering their position. Now, whilst they're considering their position, to prevent the lapsing of the DS into here, they then advised, the team and Advocate Chauke instructed the state attorney to prepare application for leave to appeal, to have it delivered urgently. And then Advocate Chauke undertook to brief the national office. The application for leave to appeal was then filed on the 16th. So that sequence, we cannot disregard it.
I accept that, Madam Chair. Now, can I continue, Madam Chair?
Yes, sir.
But what is clear, Mr. Maema, was that as at the time that, because I want to move away from this point, what is clear is that as at on the 13th of March, the 13th of March, Mr. Ngasana has not yet taken a position.
We do not know whether he has taken a position or not.
No, because you say that while the NPA was properly considering its position,
Yes,
and the NPA here you're referring to the NDPP.
that is correct.
Yes, so, and it was for those reasons that you acted out of caution by by asking that an application for leave to appeal be filed.
That is correct, Chair.
And it is at that meeting then that now that Advocate Chauke says, I will go and brief the NDPP of this decision.
Which meeting?
The meeting, the 13th. Because he says, at 423, however, while the NPA was properly considering its position to prevent the lapsing of the DS in Dukiai, the prosecution team and Advocate Chauke instructed the state attorney and holders SC to prepare application for leave to appeal and have it delivered urgently. Advocate Chauke undertook to brief the national office of the decision to appeal the matter.
Was it on the 13th of March?
I just want to clarify with the witness that was it on the same day, Mr. Maema, at the consultation, that where Advocate Chauke undertook to brief the national office of the decision to appeal?
No, I think you must ask about paragraph 42. the prosecution consulted with the holders SC, the prosecution team there, on the 13th of March. That is where Advocate Holders advised the prosecution team that he did not make a concession.
Accepted, Madam Chair. And
then they then say, whilst the NPA was properly considering his position, you can then ask the witness, when was this? When did this happen?
yes. Now, Mr. Maema, okay, let's, the chairperson has stolen my thunder there. When did the prosecution team, together with Advocate Chauke, instruct the state attorney and Advocate Holders SC to prepare the application for leave to appeal?
At the meeting with Advocate Holders.
On the 13th of March?
Yes.
And when did Advocate Chauke undertake to brief the NDPP's office? Now, when I say when, I'm not talking about the date on which he was going to make the briefing, but the date on which he made the undertaking. Would it be at the same meeting?
Yes, it would be at the same meeting.
On the 13th?
Yes.
Yes. And
Is my understanding correct that with regard to the meeting the prosecution team had with Advocate Holders SC, Advocate Chauke was present?
That is correct, Chairperson.
Thank you. Please proceed.
And at that, remember you had said in 421 that when you prepared the memorandum of the 5th of March, it was to enable Advocate Chauke to go and brief the national director.
That is correct.
Yes. Now, did Advocate Chauke ever come back to you before the meeting of the 13th of March to report to you that he has since briefed the NDPP?
No.
Yes. Okay. And then shortly you tell us at 424 that Advocate Mr. Ngasana then issued an instruction that the appeal must be withdrawn.
That the application for leave to appeal must be withdrawn.
Yes, and we can accept that would have happened after Advocate Chauke had briefed him, because Advocate Chauke undertook to go and brief him.
Well, not knowing when Advocate Chauke would have briefed Mr. Ngasana, all I know was that Mr. Ngasana issued an instruction that the appeal must be withdrawn.
Yes. Now, then happened, there was a meeting arranged for the 7th of April, 2014. Do you recall that meeting?
That is a meeting to brief the national director, yes.
Yes.
You can take the witness to the paragraphs that you are reading. It's 425.
Yeah, I'll do
It
that.
will also help us to see where you are getting the statement from. Is that the paragraph?
That is correct, Madam Chair. You said then, at paragraph 425, at page 1-117, the prosecution team was then called into a meeting with Mr. Ngasana to update him on the matter. The meeting was scheduled for the 7th April 2014. Is that correct?
That is correct, Chair.
Now, the discussion as to what was going to happen at that meeting took place much earlier. That would be around March 31st, between 28 March 24, as far back as 28 March 2014. And you can go to LO 9000947. It's LO 00947.
00947. Yes, it's this one.
Do you have it, Madam Chair? Do you have it, Mr. Maema?
Yes, I am at LO00947.
Yes. And the purpose of this briefing session would have been to update or brief Mr. Ngasana of the Cato Mena cases.
That is correct, Chair.
Nothing else.
Sorry, I have a wrong volume. That will be opinion LO4 or 4. I have LO3 or 4.
Madam Chair, whilst you're still looking for it, I'm just covering this topic, then I've got one smaller topic.
Yes,
Might
I'm
I ask that
looking
we work through lunchtime so that anyone, if we can relieve people to go home early?
No, please. Just do your work and let's finish what you're doing. I'm saying to you, I don't see LO 00947. I'm looking at LO 304. It must be 4 or 4. Is it 4 or 4?
It should be 4. It should be 4, Madam Chair.
4. So it is helpful if you do that. 4 or 4. I'll just make a note, Advocate Mtsweni, so that I'll share with my sister to see what you're referring to. Yes, I'll look for that volume.
Yes.
Yes, you were at LO 00947.
Yes. I
It
think.
should be LO 4.
Yes. Then let's just move down to. I'll start from 947 going down to 948. Are you there, Mr. Maema?
I am the Chairperson.
Yes. Remember, we know that these matters, they fall under Advocate Nogo's authority, jurisdiction. Do you recall that?
That is correct, Chairperson.
Yes. Now, on the 28th, March 2014, you addressed an email to Ms. Nuku and Advocate Chauke, and where you copied Mr. Matenja, Mr. Mlochwa, Mr. Mahlubin Tlakaza, Ms. Fuchane, and Patience Muleko. Do you see that email?
That is correct, Chairperson.
Yes. And there, in that email, you discuss, amongst others, the question of mutual assistance relating to Mr. Danikas.
That is correct, Chair.
Yes. I do not intend discussing Mr. Danikas with you because I do not intend covering that part with you. You've already testified on that. But what I'm interested in is the effect of the amount of authority that Advocate Chauke exercised over the prosecution team. And let me tell you why I'm saying that. On LO 00948, you then say in your email, Advocate Chauke, I was proposing that Advocate Nuku also be part of the briefing session on Monday, 7 April 2014. Do you see that?
I see that.
So that she can also benefit from the presentation, or any of the issues that are raised there. Do you see that?
I see that, Chairperson.
So meaning that, in fact, Advocate Nuku is in the dark about this matter. And that's why you want her to come to that meeting, so that she can at least have the benefit of what is going to be presented to Mr. Ngasana.
No, not necessarily in the dark.
Yes. But what is important, this is what you say. Remember the briefing session is the prosecution team going to brief Mr. Ngasana.
Yes.
But what you do is, you say, you ask Advocate Chauke, firstly, that Ms. Nuku should be present at that meeting. Is that correct?
Advocate Chauke, I was proposing that
Yes.
Advocate Nogo also be at the meeting.
Yes. Now, let me tell you why I say that you were...
Before you do that, let's not be selective with the information. Look at that very page that you are referring us to, and correct me if I'm wrong. The first email is the email of the 28th of March 2014 at 11:56. And the second email is the top one. Am I correct?
That is the response to the bottom email, Madam Chair. Hence, I started reading the bottom one first.
Okay. Yes.
Yes. Now, you're not just only proposing Mr. Maema. The next sentence just say, I am just not sure whether I have the authority to invite her. I just propose that if she's available, she could be part of the briefing session. Basically, you are asking Advocate Chauke for the go-ahead that Advocate Nogo be present at that meeting. That's how I interpret that paragraph. Am I correct?
Well, at the level of DPPs, I thought they could talk amongst the two.
But this was despite the matter being Advocate Nogo's matter. We're better within her jurisdiction. Now you're saying that she needs Advocate Chauke's permission to be present at that briefing session.
Now, remember, if you take the matters in chronology, at that stage, Advocate Chauke has not been asked not to be part of the team. It was at the meeting with Mr. Ngasana that Mr. Chauke was asked not to be part of this. So at that stage, he was still the coordinator of the team. So when I'm communicating with my coordinator, I'm proposing as well that Advocate Nogo also be part of the meeting.
And then...
Sorry, Advocate Mtsweni, I wanted to check that are you asking these questions with the assumption that, or not accepting that the former or one of the former NDPPs had appointed Advocate Chauke to oversee this prosecution team?
Yes, Madam Advocate Mary, will be our argument that he had no authority.
No, the authority is something else. All I'm saying is, as you put it to the witness, preface it with your understanding and your assumption, because as far as the record is before us, the Advocate Jiba had appointed Advocate Chauke to oversee this team. And up to this stage, Advocate Chauke was still in that position until maybe the next meeting on the 7th when Mr. Ngasana removed him. So, because the record might be confused that you are alleging that Advocate Chauke had a lot of power here, as if he was not supposed to be here, and whether the appointment to coordinate was lawful or unlawful, it's something that you will deal with in argument. But as the record stands, Advocate Jiba had appointed Advocate Chauke to coordinate, and he has been coordinating, rightly or wrongly, but he has been doing that. And Advocate Maema is here following the same protocol that they have been following all along, recognizing Advocate Chauke as their coordinator. So if you ask a question under the assumption that Advocate Chauke was not supposed to be there, please preface it that way so that we also don't get confused.
Okay, let me just clarify that. Thank you, Madam Advocate Meresi. Mr. You told, when the chairperson asked you whether were you there at the meeting, that Advocate Chauke was assigned the coordination role, you told us that you were not present. Do you recall that?
Yes.
Now, was it your understanding that as the coordinator, Advocate Chauke was in total control of the matter, including who attends briefing sessions with the DPP in relation to this matter?
No,
What do you mean he was in total control of the matter?
Meaning that, no, can I just ask the next question so that to a point that for other people to attend the briefing session, his permission was required?
No, his permission was not. I was not seeking permission for Advocate Noku to be in the meeting. Remember, it is just preparation stages where I am communicating with the DPP and making a proposal, who extends the invitation. I would expect Advocate Chauke to extend the invitation, and you go to the meeting and Advocate Noku is not there, and he would expect that I do the same. So rather to prevent that situation beforehand, I just say I deal with it so that we prevent a situation where Advocate Noku does not know of the meeting consent, despite the fact that she has been copied on the email.
Advocate Mtsweni, this very email of LO4 00947 of the 28th of March 2014 at 11:56, to whom is it addressed?
It's addressed to Advocate Chauke and Advocate Noku, as well as the other prosecution team members.
Let the witness just look at it. Advocate Maema. This email under discussion
Yes, Chairperson?
is actually addressed to the following: to Muiponi Noku, semicolon, Andrew K.M. Chauke,
That is correct, Chair.
and then CC the rest of those people mentioned there.
Who are the members of the prosecution team?
So the email is addressed to Advocate Noku.
That is correct, Chairperson.
Can I proceed, Madam Chair?
And you are saying in that paragraph that was read to you, Advocate Chauke, I was proposing that Advocate Noku also be part of the briefing session on Monday, 7 April 2014. Now that which appears in that paragraph will come to the attention of Advocate Noku because the email is addressed to her.
That is correct, Chairperson.
You may proceed.
But in the main, the reason you copied Advocate Noku, we find on 947 on the third paragraph. Can you look at that? Where you say, Advocate Noku, may you please peruse the affidavit that the team has drafted on your behalf.
Where, at 9?
At 947,
Or at LO 00947?
Yes. So basically, the affidavit serves two purposes. That's why Advocate Noku is copied there, because what you are sending to him, you say to her, Advocate Noku, may you please peruse the affidavit that the team has drafted on your behalf. I will come to Peter Marisburg on Monday to have the statement finalized with you. I thought the charges are withdrawn against Boyden on Monday. I should also see the Chief Magistrate to have the MLA letters issued by the magistrate. Do you see that?
I thought as the charges are withdrawn.
Yes.
Yes.
So basically, the email that was in the main to convey an affidavit to Advocate Noku. That's why she's also copied there. Not because you wanted her to be invited at the meeting.
Say again?
I'm saying when one reads the email, the reason Advocate Noku is copied in the email was not because you wanted the proposal for her.
She is not copied. She's not copied.
No.
The email
She's
is wait a minute.
sorry, sorry.
The email is addressed to her.
Sorry, I used the word copied mistake erroneously, Madam Chair. The reason you addressed that email to Ms. Nuku was, amongst others, in the main, to transmit to her the affidavit that you the team had prepared for her. It was not to convey the proposal for her to be at the meeting. That's the main reason.
The email dated 28 March 2014, 11:56 to Advocate Mtsweni as well as to Advocate Chauke deals with the mutual legal assistance. It doesn't deal with the meeting.
Yes.
Yes.
Advocate Mtsweni, how do you remove the last but one paragraph from the email and say it was not intended to convey that message? I'm lost, really. Because this is one email. It's got 1, 2, 3, 4, 5, 6 paragraphs, and those 6 paragraphs convey different things.
Yeah.
But you isolate this one paragraph where I think Advocate Nuku is made aware that there is a proposal to Advocate Chauke, or there is a request to Advocate Chauke for Advocate Nuku to be part of the briefing. So why do you sever it from the whole email?
In fact, Madam Advocate Meresi, you just submitted up that it was to convey to her that there is a request, a proposal, in a form of a request to Advocate Chauke that she attends that meeting. That is the whole point that I was trying to drive home, that for Advocate Nuku to be there, a proposal is made that she should be there, but Advocate Chauke's authority or approval is required for that.
Where do you find that? Are you reading something in
No.
that letter?
If you look at the last paragraph, the paragraph that we're talking about.
No.
Where,
I'm asking you, where do we find that Advocate Chauke's approval was necessary?
look, if Madam Chair can look at the paragraph, that's what I'm trying to direct you to.
Yeah.
Says, I am just not sure whether I have the authority to invite her. I just propose that if she's available, she could be part of the meeting. So basically, Mr. Maema is not inviting her, he's proposing, but he doubts that he can invite her. He's got the authority to invite her.
So what's wrong with that?
To say, the point is, why would she need Advocate Chauke's approval for Advocate Nuku to be present in her own matter? At the briefing where her own matters are going to be discussed. That's the whole question that
Yes.
I'm trying to understand.
I'm not answering for the witness, he will answer for himself, but Advocate Chauke, as at that time, is a coordinator.
Well, if that's the
Wait a minute. He answered earlier, said, remember that at that stage, Advocate Chauke had not been asked not to be part of the team, the prosecution team, at that stage.
Well,
So he was still, and that's the point my sister was trying to bring to your attention, Advocate Mtsweni, that they were following protocol. As at that time, Advocate Chauke had not been asked as yet by Advocate Nkasana, I think, to oust himself from the team.
okay, may I
But
just
let him just clarify it himself. But that's how I understood his answer. Please send Adv Maema.
That is correct, Chairperson. At that stage, Advocate Chauke was still the coordinator of the team. He had not been removed as coordinator.
now earlier you testified about the.
Before you go about that, let's go back to that very point.
No, I think I accept the answer, Madam Chair. Then I'll leave the point.
So you are leaving that point.
Because that's how the panel understands it, cannot take it beyond that. And that's how the witnesses answered
Do
it.
you understand it differently yourself?
I understand it differently. That's a matter of argument. But it's not about me, how I understand it. It's about the panel because...
Well, you have put it to the witness. I want us to tie it up.
No, Madam
So
Chair.
I was saying that he answered that very point, and I'm saying to you, does it rest your case here, or you want to pursue that?
Now, I will not pursue it.
Thank you.
But just on the question of protocol, which from the email we understand to be saying that you required Advocate Chauke's approval as the coordinator of the team. For you to speak to Advocate Noko regarding the prosecution, the poker authorization application being made in her name, did you first seek Advocate Chauke's approval before you can speak to Advocate Noko, or you went on your own and spoke to Advocate Noko?
No, I spoke to Advocate Noko on my own.
You did not need Advocate Chauke's approval?
No.
Okay, thank you. Now, we then go to the meeting of the 7th, where you say that Advocate Chauke was relieved of his coordinating functions.
Just hold on that point. I want to make a follow-up on that last point that you made. Now that you had been following protocol, why is it that this time you communicated directly to Advocate Noko and not through Advocate Chauke?
Chairperson, I think at that stage I had I already had the numbers of Advocate Noko. That is why I just communicated with her directly.
Am I right that it was not a question of you following protocol or not? You had been in KZN with your team and you decided to communicate with her directly?
That is correct, Chairperson, yes.
And as you did, Advocate Chauke was still part of, or rather, he was still part, he had not been asked to leave.
That is correct, Chairperson.
It is not clear to me that similarly, this is the inconsistency of you following protocol, and sometimes you follow it, sometimes you don't follow it.
Chairperson, if one looks at that email, I see I directed it to Advocate Noko, and then I also added Advocate Chauke so that he knows. It is sent to both of them, so that both of them are aware of where I am with the mutual legal assistance of Mr. Danikas.
Yes. But I thought Advocate Mtsweni was now asking you about you having spoken directly to Advocate Noko when the issue of authorization came up. Did I understand you?
That is indeed so, Madam Chair.
And you said that this time you spoke directly to Advocate Noko. You didn't speak through Advocate Chauke.
Chairperson, I only spoke to Advocate Noko once the issue of the authorizations was completely dealt, was final. Remember, it was finalized on in August already. Now, in August 2012. Now, in March 2014, when I speak, because Advocate Noko was already the coordinator of the team, I was speaking to her directly.
When you spoke to Advocate Maema, having spoken directly to Advocate Noko in relation to the authorization, are you suggesting that there is any communication, documentary communication from him directly to Advocate Noko, or if not, just put that clearer?
No, Madam Chair, I think Madam Chair summed it up correctly. The inconsistency, because at one point when it suits him, he's following protocol. When it suits him, he's not following protocol. And I say this because on the question of the authorizations, which happened in 2012, in August 2012, Advocate Chauke was still the coordinator of the team. And yet, Advocate Maema speaks directly to Advocate Noko and makes an arrangement that Advocate Chauke will sign the application on her behalf. He does not ask, because I asked him, the question of the arrangement, did you get it through Advocate Chauke or not? He said no. I spoke directly to her. And at that time, mind you, Advocate Chauke is still the coordinator of the team. Now, when it suits him, he communicates directly to, he does not follow protocol, but now on other instances he follows protocol. That's the question, that's what I was trying to grapple with. Because even on both instances, even at the time when he sent this email, Advocate Chauke was still on his version, Advocate Chauke was still the coordinator of the team. Because it was the 28th of March, and he had not yet been relieved. 28th of March 2014, he had not been relieved of his duties. He was relieved a week later.
Yes. Can you take us to that part where we spoke about him I can't remember now where we spoke about an arrangement being made that Advocate Noko will sign, or is it Advocate Mlojo?
It is that Advocate Chauke will sign on Advocate Noko's behalf.
Would you take us back to that document if you remember?
I think it is it's in the LO bundles. Yeah, Madam Chair, it's LO. It's LO 00665.
What volume is that?
I think it should be LO 3 or something like that. 665.
Yes. LO3. Take us there.
It's LO 665, where it is the application for authorization, which is made in Advocate Noko's name, but Advocate Chauke signed. You would recall that I asked the witness to say the application is made in Advocate Noko and in his name, and he testified when Mr. Ngaitobi asked him about this to say, well, there was an arrangement made between him and Advocate Noko that Advocate Chauke will sign. And I asked him that you mentioned arrangement between, first he said there was an arrangement made between him and Advocate Noko. And then he made mention of the arrangement between Advocate Noko and Advocate Chauke. And then when I asked him question earlier, I asked him that you know about the arrangement between Advocate Noko and Advocate Chauke through Advocate Chauke. He said no. He was told that by Advocate Noko when he spoke to her.
Madam Chair, we don't accept that rendition of the facts, but I don't want to interrupt the cross-examination, just to register that we don't accept that our learned friend is correct in the recordal of the facts.
The record will speak for itself, Madam Chair.
You remember, Council, you remember when you spoke, when you dealt with the centralization application, you referred us to LO 00856.
Yes.
That letter by Advocate Noko to Advocate Jiba on the 20th of August 2012. You remember?
I recall that, Madam Chair.
It was that similar application in relation to the Rustenburg documents.
Yes, Madam Chair.
And you mentioned that the wording is the same as that in LO 00859, where Advocate Maema signed PP.
Yes.
Then you referred us to this document, LO 00856.
Just to interpose, Madam Chair, even in response to that, he said there was an arrangement between him and Advocate Noko that he will PP on, he'll sign on her behalf.
Yes, I'm going there.
Yes.
And then you said you had made an arrangement with the Noko and Chauke that you sign, asking the witness. And then you said she denied knowledge of that. That the application was to happen in her name. And then you said actually she was very adamant that she knew nothing about that.
Yes.
And of course you referred to that document entitled Monetary Awards. But that arrangement point, you remember there was a page where it is stated that an arrangement was made that someone will sign.
It's an email.
It's an email.
It's an email from Advocate Maema.
It pertains to this.
Yes. I
Take us to
think he can, just cannot recall where the document is.
If you can ask your junior behind you, the NPA team, to assist us, or your attorney next to you, I'm looking for that document because we spent a bit of time on it.
Madam Chair, you'll find it on LO 00778.
Yes, I see that, but this is not a document.
Now, if you read the email in the middle there, where I think it's from Advocate Maema, dated 15 August 2012, where the second paragraph on this email, the last sentence, it says, I have done the prosecution memo on the KZN letterhead, although our DPP will sign as arranged with acting DPP KZN.
Yes, I see that, but there is a part that we dealt with at length earlier on. But we may proceed, I'll find it.
But I think, Madam Chair, just so that we could just clarify, so that we can just put this matter to bed. You wanted to say something, Madam Ramaha?
Yeah, maybe through the chair.
Sorry
I
for
think
taking
th-
over.
This issue, Chair, that relates to this document, this LO665, was dealt with in the evidence of Advocate Nuku on the date. But then where she actually totally dissociates herself from the document, and that's when she gave evidence that she informed the evidence leaders of the Zondo Commission that she did not know that document and she was not the scribe of that document. Let me just check the date of the evidence presentation. It seems to be the 5th.
Yeah, please bear with us. There's many documents here. 786. Advocate Mtsweni, I think you must proceed. Just clarify with the witness again, because I can't find my notes.
Adv Maema, just deal with the firstly on LO856.
856.
Yes.
I'm there, Chairperson.
That is the centralization application that you signed. Do you recall it?
Reminded me twice that we should take a comfort break. How long are you still going to be with the witness? So
Now,
that
after
we
this,
can
Madam Chair, I
determine?
won't be more than 10 minutes.
My sister is giving me a nod that you can proceed and finish.
Okay.
You may proceed. Counsel.
This. Advocate Maema, do you recall earlier when we discussed the centralization application? That was, remember there was the first one that was done by Advocate Chauke in his name that you said, in fact, it was prepared by yourself.
That is correct.
But it was signed by Advocate Chauke.
Yes.
And then on the 28th of August, you prepared another centralization application,
Yes.
and this time signed by you.
Signed PP, yes.
Yes. And that signature, was it in terms of an arrangement between yourself and Advocate Nuku?
Where I would sign on her behalf, it would be pair arrangement.
Yes. And that arrangement would have been struck between yourself and her directly?
Yes, telephone.
Yes. Not through Advocate Chauke?
No.
Yes. And I take it the same as the poker authorization of the 15th of August, where you said there was an arrangement that Advocate Chauke would sign on Advocate Nuku's behalf.
Yes, that arrangement was done with Advocate Noko.
And yourself,
Yes.
directly.
That is correct.
without Advocate Chauke's intervention.
I would have accepted that the two DPPs would have spoken.
No, but I mean, when you spoke to Advocate Noko, you did not speak to her through Advocate Chauke.
No,
You spoke to her directly.
directly, yes.
Yes. I think, Madam Chair, that puts the matter to bed. Now, as I we know that on the 7th of April, Mr. Ngasana eventually withdrew whatever
2nd April of what?
7th April
7th April
2014 at the briefing meeting. Do you recall that?
I recall what happened.
That at that meeting, Advocate Chauke was relieved of his coordinating duties.
Oh, yes, yes.
And then on your version, he stood up and left because he was sitting next to you.
That is correct.
Yes. And we know that Advocate Ngasana eventually vacated the office in May 2015. And on the 18th of June, Advocate Abrams was appointed as the NDPP.
Yes, he was appointed later. I cannot
Yes.
put
But-
my hand on a date.
But after his appointment, the decision by Mr. Ngasana that Advocate Noko should run with the matter, coordinate the matter, was still standing.
That is correct.
Advocate Noko was never relieved of her coordinating duties.
That is correct.
And that would mean that Advocate Chauke had no authority moving forward to be part of this matter, of the Cato Mena matters.
That is correct.
Yes. Now, you see, I'm asking this because if you go to LO 00990,
What is the volume?
should be volume 4, Madam Chair. 990. Yes. Nine nine zero.
And take us to the page.
It's LO 00990. Are you there, Mr. Mang?
I'm there, Chairperson.
Yes, those are the minutes of a meeting that took place on the 16th July 2015. Do you see that?
That is correct.
And the way a year after Mr. Ngasana had told Mr. Chauke to never be part of the Cato Mena matters again.
You see,
Aren't you using, strong language? To never be part.
Okay, so let me just. Where he had relieved Mr. Chauke, Advocate Chauke, of his coordinating duties. Remember, it happened on the 7th April 2014.
Chairperson, when I look at the names of the person who are present at that meeting, 16 July 2015, you see the DNDPP is
No, Mr. Maema, I never asked you about the people who were there. I'm saying that those are the minutes of the meeting that took place on the 16th of July 2015, a year after, almost more than a year after Advocate Chauke was relieved of his coordinating functions over the Cato Mena matters. That's the question.
Yeah, but I'm
No,
talking
it's
about.
not more than a year, some months. Remember,
It
the
was-
meeting was on the 7th of April 2014.
Yes, and the meeting is on the
And
2015.
this one is, July 2015? July 16. Yes.
Chair, through you, but Advocate Mtsweni, also factor in the intervening action that happened. When you talk 7th April 2014, that was Mr. Nxasana, but now we are at 16 July 2015.
I'll come to that, Madam Chair. I know where you're going, Madam.
Yes, I'm saying when you put it to the witness,
Yes.
make sure that you recognize the intervening
Yes.
action that happened.
Now, Mr. Maema, we know that Advocate Abrams came into office on the 18th of June 2015. Do you recall that?
I remember it was in 2015.
Yes. Now, insofar, and at that time, you are still part of the prosecution team.
Yes.
Insofar as you are you aware of any instance where Advocate Abrams reinstated Advocate Chauke as part of the coordinating team or part of the team dealing with the Gauteng matters?
I'm not aware.
Yes. And had you been aware, had that been the case, you'd have been aware. Because
Yes.
you are the prosecution, you are the team leader.
That is correct.
Yes. Now, what you and I were dealing with minutes of the meeting that took place on the 16th of July 2015. And present at that meeting is Advocate Jiba, Advocate Noko, Advocate Chauke, Advocate Matenja, and Advocate Matenja, would I be correct that would be the Matenja was part of the prosecution team because it's a DDPP.
That is correct.
And it's Advocate Mlocha, who is also a DDPP.
That is correct.
Yes. And Advocate Mosing, and Advocate Muleko, and Tsepo from the Legal Affairs Division. Do you see that?
I see that, Chairperson.
Yes. And what is being discussed under outstanding issues on 991 is that it is recorded that Advocate Chauke to meet with the intelligent guys and then says the team must be vigilant in the manner in which they deal with the investigators. And then Advocate Noko then wanted Mado to be called as a witness as he supports the case against Poison. Do you see that?
I see that, Chairperson.
And we know that
Sorry, your name does not appear in that list.
I was about to
no.
raise it, Chairperson.
I'm well aware that you're not there, Mr. Maema.
I'm asking the witness.
Oh,
a question.
sorry, Madam Chair.
You'll ask your own question. It is a respect thing,
I apologize, Madam Chair.
Advocate Counsel. You don't get into the the mouth of anybody. You'll have your questions, you'll have your time, but don't interpose like that. I just ask because I look at this list that you are referring us to, and I want to verify with Advocate Maema whether he was present at that meeting, and he says he was not. Am I correct?
That is correct, Chairperson.
Were you aware of it?
I cannot remember, Chairperson, but I should have been aware of any meetings of Gauteng.
And Council is now asking questions about what seemed to have been discussed at that meeting. Would you know?
Chairperson, because of my absence, I was waiting for the question to see whether I can deal with it. But
You may proceed, Advocate Mtsweni.
Thank you, Madam Chair. The point that I was trying to point to you was that it appeared, okay, let me just take you through I've taken you through what it was suggested Advocate Chauke was to do on 991, and then we go to 992 under mutual assistance. Do you see that?
I see that, Chairperson.
And it is said that the documents are ready, and Advocate Maema handed them to the DPP KZN. It was mentioned that Daniko's, the Greek witness, has dual citizenship. Other methods to bring the witness other than MLA to bring the witness discussed. Witness willing to come to embassy on condition is afforded protection. It was suggested or concluded that MLA must proceed whilst waiting to try other options to bring him to the embassy. Fresh application for authorization for poison. Do you see that?
I can see that, Chairperson.
Now, I don't want to take you through the whole thing, but the point of the matter is, in light of the fact that Advocate Chauke had been relieved of his coordinating duties, do you recall that?
Yes.
And yet we still see him participating in meetings where strategic decisions are taken regarding the Cato Mena matter. That would be highly irregular. Would that be correct?
I
Especially
agree.
in light of the fact that you told us that you are not aware that he had been reinstated to the coordinating team, to coordinate the team. That would be highly irregular for him to participate.
I agree with you, yes.
Yes.
As a follow-up, Advocate Maema, was Advocate Chauke barred from ever attending any meeting that would discuss the Katomena case?
No.
May I continue, Madam Chair, just a follow-up question on that? I'm waiting for the chairperson's direct.
The last point you are making about the documents being handed to someone, where are you reading it from, Council?
Yes, under mutual legal assistance.
LO00992. Yes, mutual legal assistance. Just repeat the question there.
I'm saying that I just read to him what was being discussed there, and I said it is clear that what was being discussed related to the Cato Mena case.
Yes.
Yeah, that's what and he said yes. But Mr. Maema, I've just picked up something. If I can just clarify it with you through the chairperson.
You may.
If you go to 994,
I'm there, Chairperson.
under Captain Botha, do you see that?
I can see that, Chairperson.
Can you read that into the record?
Advocate Maema indicated that the team should look into the charging of Captain Botha with defeating the ends of justice for giving statements to the opponents.
Now, could you have indicated could you have made such statement if you're not at the meeting?
It's impossible. In fact, I'm shocked about this. I have never indicated as such.
Okay. Madam Chair, I think I'm done with my questioning. Can I just have 5 minutes through you to confer with my instructing attorney, just to make sure that we've covered everything? Sorry to interrupt. I do not intend going to the record hearing issues. Mr. Maema has testified extensively on that.
Yes. I just want to make a follow-up on these very documents, the minutes. You referred us to page LO00990, reflecting the people who were there. Mr. Maema was not there. And the minute itself then tells us at LO 00994, it suggests that Mr. Maema was there.
That's why I asked him to say,
Yeah.
is that correct, based on what he says,
Yes.
that he was not there?
It puts into question the correctness of this minutes, doesn't it? Or are you going to call the person who took the minutes?
I think
The witness says I was not there, and the page 1 shows that he was not there. And this other page, 00, LO 009, 994 says Maema, Advocate Maema indicated that the team should look into charging Captain Botha.
Madam
And
Chair,
then the meeting adjourned, and then in bracket, Advocates Jiba, Chauke, Noko excused.
yes. Madam Chair, we'll look into calling one of the people, whether we'll do an investigation on the minutes, and then if needs be, we'll call someone to talk to the minutes.
Is the point you're raising with the witness with regard to this document that he was present?
No, I'm not raising it with him. It was in relation to Advocate Chauke's participation at that meeting where Ketomena matters are being discussed.
Oh, yes.
Whether that was proper or not.
Yes.
Yes, that was only in relation to that.
But then these minutes are now revealing something that is worrisome, where the witness is not reflected as having been present, and he testifies to that effect. But then the very minute says he was present.
I appreciate that concern, that it brings into question the credibility of the minutes. So, but what we would ask is that the chairperson provisionally accepts the minutes, and then we'll find if during our investigations it turns out that the minutes are inaccurate, we'll place it on record, and then we'll ask that any evidence in relation to these minutes be ignored. But should we find someone who will confirm the minutes, who will bring that person here, Madam Chair? Because at the end of the day, there's an inquiry. It must have all the facts and decide the matter. So for us to say that you should not have regard to them now, and then later that they are confirmed, then that would mean that the inquiry would be deciding the matter on scanty evidence. So hence I'm asking that for now, let that evidence be allowed. But then if we will be honest with this inquiry, that if we talk to people who says there was never such a meeting or anything, we'll bring that to the attention of the panel, and then we'll ask that those parts be struck off.
My further concern with this minutes is it doesn't show. I mean, if you look at LO 00994, right at the bottom, it says the meeting adjourned and the following were excused. Then, meaning the meeting continued. And then it has a further heading, directive to the team. And then there is the team that remained behind to draft a memorandum, but we do not see the ending of that. Of those minutes, which would maybe give us an idea who drafted these minutes, and yeah. So maybe if you can get a copy of these minutes, or whoever drafted the minutes.
We'll do so, Madam Advocate Pere.
Thank you.
Does that end your questions?
That ends my questions,
Does
Madam.
that end your
Yeah, but
questions?
thank you, Madam Chair. Thank you, Mr. Maema.
But do remember this point that you've just raised with you.
Well, I'll make sure it'll be it's one of my priorities. It's on my priority list, Madam Chair.
Yes. Advocate Kwatobi, it's 2:00. I think we should pause for lunch. Maybe I should find out from you how long do you think you'll take with this witness, so that we can determine our lunch break time.
Madam Chair, I will not be longer than 15 minutes.
May we then pause just to stretch our legs, even if it's for less than an hour, given the fact that it's Friday, the people might want to travel. And then we reconvene and you finish your re-examination.
Indeed, Madam Chair.
I know you people are provided with lunch. How long do you think it will take you to have your lunch?
Madam Chair,
Advocate Mtsweni?
30 minutes.
30 minutes.
Yes.
I'm glad that we spoke on my behalf. That's what I might be clever.
Are you happy with 30 minutes? Yes, we will adjourn for 30 minutes, and that is until 2:30. Advocate Maema, you are still under oath to come back and finish.
That is correct, Chair.
We will pause for a very brief lunch. Thank you. A very good afternoon to you all. Good afternoon, Advocate Maema.
Good afternoon, Chairperson.
Advocate Chauke. Advocate Gauteng. Advocate Maema, you are under oath.
That is correct, Chairperson.
Thank you, Madam Chair. Good afternoon, Advocate Maema. Can I start with
Good afternoon, sir.
Section 24 of the NPA Act? I think it's LG.
I'm there, Chairperson.
Yes. Now, LG 00194. Yes. Now, this section is applicable, according to its headings, to directors and deputy directors, correct?
That is correct, Chairperson.
And those are what we've been referring to as DPPs and their deputies.
That is correct, Chairperson.
Now, the first thing is, what is the relevance of this in the racketeering case, which is a national jurisdiction, NDPP, let me not use national.
Well, Section 24 sets out the duties and the
Yes, now
powers.
we know what it deals with. I'm asking you a different question.
Oh,
What is its relevance to a charge like racketeering, which is subject to the NDPP's jurisdiction?
well, Chairperson, directors and deputy directors would prepare the documents relating to the request for racketeering authorizations.
I understand, but who makes the decision on those? Whether to prefer a racketeering charge or not?
The DPP, the national director does.
Yes. Now, this is the point. What I don't understand with the case of the NPA, the case of the evidence leaders that has been persisted with. Advocate Batoi said this case against Advocate Chauke is only about racketeering, not about the subsidiary offences.
Yes.
Yes. Now, if it is not the authority of the DPP to charge a person for racketeering, whose authority is it?
It is the authority of the national director to charge
Yes.
in that respect.
Now, who has to decide who must play a coordinating role to oversee a racketeering charge?
The national director.
So if the national director chooses Mr. Maema, is that objectionable?
That is not objectionable, nor can Mr. Maema refuse the direction of the national director.
Yes. If the NDPP chooses a DPP to oversee on the behalf of the NDPP, is there anything objectionable?
There is nothing objectionable in that respect too.
Yes. Now, when you look back then at this section 24, in terms of its content, this is what it says. It says, subject to the provision of section 179 and any other relevant section of the Constitution, this Act, or any other law. So if you just specifically refer to any other law, is there any other law that deals with racketeering other than the NPA Act?
The Prevention of Organized Crime Act.
Yes. And where does it assign the jurisdiction?
There is jurisdiction in respect of racketeering
Yes,
offences.
yes.
It assigns it to the national director.
Okay. So the very section that Mr. Chauke is being hanged upon contains an exclusion. If there is any other law, that law is to be followed.
That is correct, Chairperson.
That is the meaning of the word subject to.
Yes.
Yes. So do you have any idea why we've been discussing this when it's so clear in the legislation?
I have no idea, Chairperson.
Yes. I want to ask you then something else. Do you have the charge sheet, the terms of reference, in front of you?
Yes, I do.
Yes. And if I can ask you to go to page 4 of that document, to paragraph 3.1.1.1.
Oh, yes, I am 3.1.1 on page 5.
Yes. Now, this is what Advocate Chauke is charged with, is for supporting a decision to prosecute the accused, notwithstanding that there was no evidence justifying the decision. Have you been asked any question about the existence or otherwise of evidence by the evidence leaders?
No, Chairperson.
Have they even put it to you that there was evidence or there was no evidence?
No, Chairperson.
Yes. Have they even put it to you that there was insufficient evidence or there was no sufficient evidence?
No, Chairperson.
Yes. Now then it says, and he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. Now, did anyone sign the case dockets in this case?
The signing of the case docket does not make sense. No one signed any case dockets.
Case docket is not something that is even signed.
Yes.
And then it says, and or prosecution memorandum. Who signed the prosecution memorandum?
Prosecutors sign prosecution memorandum.
And in the Cato Manor case, who signed it?
I signed the prosecution
Did
memorandum.
Advocate Chauke have any role to play in trying to get you to sign it, or trying to get Advocate Mtsweni to sign it?
Not at all, Chairperson.
Yes. And then it says, detailing the alleged evidence implicating the accused on which the decision to indict had to be made. Now, let me also tell you something. When I cross-examined Advocate Batoyi on this charge, she said the word docket or prosecution memorandum are wrong. It should be indictment. In other words, the charge should be that Advocate Chauke tried to force Advocate Mtsweni to sign the indictment. That's what she said. Now, the most astonishing thing is that today I asked in my objection for evidence that of the instruction by Advocate Chauke to Advocate Maema. To Advocate Mtsweni. Can you remember the response that came from the evidence leader to that objection?
No, I cannot, Chairperson.
Well, the response was that he withdraws the question and that it was a wrong question.
Oh, yes, earlier on today.
Yes, today.
Yes.
Yes.
No, now I understand you.
So even the evidence leaders cannot find the instruction that Advocate Batoyi is talking about.
That is correct, Chairperson.
Now, you see what gets worse here? If I can ask you to look at the signed statement of Advocate Batoyi at page 74. Do you have that?
I am at page 24, Chairperson.
At paragraph 180.3.
At 180.3, Chairperson.
What does Advocate Batoyi say about that in that allegation?
Advocate Chauke attempted to force Advocate Mlojwa to sign the Boysen's indictment in June 2012 without providing him with dockets or summary of the evidence allegedly implicating Boysen, which Advocate Mlojwa had specifically requested from Advocate Chauke to enable him to consider the evidence and to decide whether to authorize and sign the indictment.
Yes. Carry on the next sentence.
When Advocate Mlojwa refused to sign the indictment without a docket or a summary of the evidence, Advocate Chauke threatened to report Advocate Mlojwa to the NDPP and the Minister of Justice if he did not sign the indictment.
Yes, now you can just stop there because thereafter it's their own commentary. But factually, the accusation is that there was an attempt to force Advocate Mlojwa by Advocate Chauke to sign an indictment, which was, they attempted to put it to you today, and we asked for it. They say they withdraw the question. I mean, why would they put something under oath which they cannot establish on evidence?
It doesn't make sense at all.
Yes, but what are the implications for Advocate Vatoi, who has written the affidavit?
Well, it has serious implications. She has made a statement with, in my view, appear to be false.
And you said that what distinguishes a perjury from a negligent false statement is what?
Say again.
I'm saying what distinguishes a crime of perjury from a negligent false statement is what?
Because there is an intention to deceive.
Yes. Here, is there an intention to deceive, just reading from this?
It is clear there is an intention to mislead, yes.
Thank you very much. Now, we've gone through that first paragraph because the questions seem to revolve around that. Now, you were also asked at length about Advocate Chauke purportedly exceeding his jurisdiction to get involved in KZN matters. You remember that?
That is correct, Chairman.
Now, you had told us when you started that you have read the terms of reference. Is
That
there
is correct.
anywhere in these terms of reference where the President wishes this panel to decide the question of the excess of jurisdiction of Advocate Chauke?
No, there isn't, Chairman.
Yes. So much so that the best that the evidence leaders could come up with is paragraph 3.2.1 to justify why they were questioning you about Section 24 of the NPA Act.
Yes.
But there is no section there of the Constitution, no section of the NPA Act, no reference to the Code of Conduct, or any clause in the Code of Conduct, rather. So how would anyone know how they should defend themselves against a nebulous charge like that?
It makes it very difficult, Chairperson.
Yes. Now, thank you. Now, if you just go back to where it is more specific, 3.1.1.2, 3.1.1.3, 3.1.1.4, and 3.1.1.5. You can tell me if you disagree, but when we began these proceedings, the chairperson used the phrase, the golden thread that connects all of those charges is that the NPA alleges that the decision to institute the charge against the Ketumano accused was based on no evidence. Would you accept that characterization?
I would never accept it at all.
No, I'm saying, would you accept that the charges require the NPA, the evidence leaders to prove that there was no evidence?
Yes, it does.
Yes. And how do you respond then at the fact that there is not a single attempt to establish that there was no evidence?
Well, it leaves one to beg, where does this assertion come from?
Yes. Is it correct that you spent 3 days in your own evidence establishing the evidence?
That is correct, Chairperson.
Yes.
And we're talking about ample evidence, not just evidence.
Yes, thank you. Now, could I then leave the issue of the analysis of the charge sheet against Mr. Chauke and go to, there was an accusation made against Advocate Noko that she could have perjured herself. Now, a perjury charge is a serious charge, especially if made against an advocate, or a perjury accusation. So it has to be based on correct facts, like you've done in relation to Advocate Batoyi, paragraph 180.3, that it's clearly a false statement made with the intent to deceive.
That is correct, Chair.
Now, I had asked my colleagues in the course of the adjournment to print the portion where Advocate Noko responded to this issue of the arrangements to see what she actually said in order to decide whether the imputation was fair or unfair. And if I could ask my attorney to distribute it.
Thank you.
Now, that document in front of you is a record of the evidence given by Advocate Noko on the 5th of February 2026. And if you look, initially it starts with Advocate Mtsweni and then Advocate Noko, yeah. Now, there is a specific question by Advocate Mtsweni. What does it say on line 6?
Chairperson, it says, was there an arrangement between yourself and Advocate Chauke that he would sign documents on your behalf?
And what does Advocate Noko say?
Advocate Noko then responds, no, I did not have that arrangement with Advocate Chauke in that respect.
What was put to you this morning? Was this the same question or was it a different question?
It was a different question.
Which was?
Which was there an arrangement between myself and Advocate Noko?
Exactly. Is this the question she was answering then?
No, it was answering a different question.
Yes. So now when it is claimed that she could have perjured herself, is that a fair claim?
No, it cannot be a fair claim, Chairperson.
Yes. Then there is also the last point I want to check with you is around the involvement of Advocate Abrahams. If I could ask you to go to page LO00990. Correct. Thanks.
It should be volume 4, Council.
No, I'm told I've got the wrong end of the stick, not for the first time, which is, it's B02721.
B.
02721. B8.
Thank you, Chairperson. I'm at B02721.
Yes, let's just give a second to the panel to get there.
B02721.
Is that correct? Yes, Madam Chair. Apparently it's B11, not 8. Oh, it says file 8. B11, so it's B02721.
Thank you, Council.
Thank you, Madam Chair. Now, just to put this in context, Advocate Maema, the accusation is that Advocate Chauke, after being removed in 2014 on the 7th of April from the Cato Mano case by Mr. Nxasan, reinstated himself in 2015 on the 6th of July, correct? That's the accusation that was made.
That is correct, Chair.
Now, I want to show you in 2016, a year later what Advocate Abrams was saying. Now, that document is the internal memorandum to Advocate Jiba and to Advocate Chauke and to Advocate Pretorius and Advocate Noko. And what is the subject there?
Ketomena prosecution team,
Yes. And then it's dated the,
8th of April 2016, Chairperson.
yes, just read the first two paragraphs only.
Dear colleagues, as you are aware, the Priority Crimes Litigation Unit, brackets PCLU, reports directly to me. The 3 Deputy Directors of Public Prosecutions seconded to the PCLU will be the prosecutors in the Ketomena matter, namely Advocate Adv Maema, Raymond Matenjwa, and Jabulani Mlojo. I would like to take this opportunity to extend my deepest and sincerest gratitude to Advocate Chauke for his leadership and assistance during his involvement in the matter, as well as to Advocates P. Fuchani, M. Ntakaza, and P. Muleko for their very sterling work and commitment.
Yes. Now, what do you make of this? Because this is now a year later. What is the NDPP saying about the involvement of Advocate Chauke? Is he endorsing it or rejecting it?
He's endorsing it and applauding the members for the contributions they made.
But specifically applauding Advocate Chauke.
That is correct, Chairperson.
I mean, he calls it a sterling work.
Yes.
So do you understand why the NPA now has an issue about the involvement when actually the NDPP at the time was very enthusiastic about the involvement of Advocate Chauke?
It doesn't make sense at all.
Thank you, Madam Chair.
Councillor, should we understand this communication by Advocate Abrams to Advocate Jiba, Advocate Chauke, Dr. J.P. Pretorius SC, Advocate Noko, to constitute a reinstatement of Advocate Chauke to the position he held before this period?
No, Chairperson, I do not understand it in that way.
Remember, he was excused from performing the functions that he had been assigned by Advocate Jiba.
That is correct, Chairperson.
He was relieved of the functions.
That is correct.
In 2014, I think?
Yes,
Am I correct?
In 2014, yes.
2014. 2 years later, Advocate Abrahams writes to say, commendable.
Yes,
Well done, Advocate Chauke, for the sterling work.
that is correct.
That's why I'm asking you the question. Does it mean that he is now back into the picture?
No, Chairperson, he is not back in the picture. All that happens is he applauds the work, the previous work that was done, seeing that this applaud was lacking from the side of management, of senior management.
Advocate Gatobi, there is that issue about the minutes that were referred to us that seems to be confusing. the authenticity of this minutes may be creating problems to us because they say one thing that Advocate Maema was not there. He has testified to that effect. But the very minutes then later says Advocate Maema was there.
Yes.
Advocate Mtsweni has undertaken to verify with the scribe of this minutes, and if necessary, they may call the scribe. But of course, the last page of the minutes, as my sister Advocate Baloy Mere indicated, correctly so, the last page of the minutes is missing.
Yes.
So we don't know who signed these minutes.
Yes.
We'll park it there.
Yes. Thank you. They are also odd. A lot of the minutes are written on the letterhead of the NPA. These are just written on a blank piece of paper.
Yes. There is another point. That was made. With regard to the involvement of Advocate Chauke post 2014. Yes, I think you've covered it.
Yes.
It is that point regarding Advocate Noko
Yes.
that
Indeed.
you started with.
Thank you.
Yeah. This brings us to the end of your testimony, Advocate Maema.
Thank you, Chairperson.
It has been a long slog indeed of sitting on that chair, helping us to ascertain the truth with regard to the issues raised in the terms of reference.
That is correct, Chairperson.
That is where the mandate of this inquiry lies.
Yes.
And we would like to thank you sincerely for having made time to come forward as a responsible former DPP or deputy DPP who was directly involved in the prosecution relating to the Gauteng matter. Of course, it has not been an easy road, not only for you, but for all of us. But we take this opportunity to thank you sincerely for having made time. You are going to be excused now, and we will proceed with the business of the day.
That is correct, Chairperson.
Thank you. You are excused, sir.
Thank you, Chairperson.
Advocate, you may switch off your mic, Advocate Maema. Advocate Kwatobi, what is the position regarding your next witness?
Madam Chair, firstly, I will be calling, I think he's Lieutenant Colonel Chris Mangena as my next witness, who is a ballistic expert. We have taken a fairly detailed statement, but I'm afraid to report that we have not yet finished. We believe that we will be finished during the course of Monday. We would like to ask, Leonard Jr. insists that I should ask for Wednesday, but I would like to ask to start on Tuesday to give us time to finalize the statement and to circulate it. we undertake to circulate it during the course of Monday.
You are actually asking for a postponement to Tuesday, Advocate Nkabinde.
Yes, I am.
And we have been told 2 days earlier that your juniors had been preparing the statement of Lieutenant Colonel Mangena.
Yes.
We all know by now, having read his expert report, which forms part of these bundles.
Yes.
And I don't think any issue is taken or will be taken about the content of that ballistic report. I'm rushing to say that, but it seems to me that these are expect findings which on the records before us have not been contradicted by any other aspect.
Yes.
That being the case, of course, I bear in mind that you say your statement is detailed, but is it a repetition of what we have already?
No, Madam Chair, it's not. I've only been in the consultation only for one full meeting with him, but it's not a repetition. There are 10. Firstly, the record we have only has, I think, only has 5. The records we have in this inquiry. He actually did 10. 23. Well, yes, he did 23 in total, but we only have 5 from him here. So,
Beg your pardon, repeat yourself?
yes.
The
So
record
our
we
current
have-
record only has 5 reports from Lieutenant Colonel Mangena. But in reality, he did 23 reports. So the statement that is being prepared covers all 23.
Does he have those remaining 23 reports,
Yes, he has them.
which do not form part of these bundles?
Yes, they were copied. Yes, they were copied by my attorney. They can be added to the record of this inquiry.
Yes, because this assists us in evaluating whether we should postpone to Tuesday. As you tell me that the majority of those reports are not forming part of this record,
Yes.
it seems to me that that might necessitate a longer consultation and longer
Yes.
a statement by him,
Yes.
because he's bringing a totally new evidence that is not before us.
Yes.
Advocate Nkabinde, I think a postponement, my sisters agree that we may postpone to Tuesday to enable you to finalize the statements, make copies, and copy your colleagues and us. But you have a full weekend. Your juniors should run around this weekend, Advocate Chauke, by order. And to
Listening.
saying, this is a weekend, juniors. You have no weekend. We would like you to finalize these documents, and we should have them online. The evidence leaders and Advocate Halley, all in sundry, should have those documents, so that at least we can have Monday to read them. Because we cannot start by Tuesday not having read those documents. It takes a bit of time to do that. So we request that you work throughout the weekend, and then you file online and copies to be made. I believe this office, I see one of my very able administrative officer is nodding her head that it is possible. She will definitely be here if your juniors need the assistance. I'm sure our researchers can also make themselves available to assist. As you recall, we work as a team here to make sure that we finally have documentation as an inquiry to proceed with the matter. So it's not a question that they don't work for you, they work for all of us, and all your juniors must assist everybody, because we are in a fact-finding mission here. Before we finalize this matter, let me hear from the evidence leaders whether they are opposed to a postponement to Tuesday.
No, Madam Chair, we're not. We're not opposed.
Advocate Halley, you must have heard that we are inclined to postpone this matter to Tuesday because the next witness, as you entered there, they were dealing with the long statement that has been prepared by Lieutenant Colonel Mangena, the ballistic expert. We had thought that his evidence was going to be brief because we have already in this record his expert reports, I think about 2 or 3. We are now told that, in fact, he prepared reports in almost the 23 dockets. And I'm sure that is why this consultation is taking longer. And in hindsight, after hearing what Advocate Andrew tells us, we think that a postponement to Tuesday will be appropriate so that we can all have the statement and attachments, then we can start on Tuesday.
That is an order from our side.
Thank you very much, Advocate Nkabinde and team. We will postpone this matter to Tuesday. I always forget the dates. I suppose it comes with old age.
24th. I hope so. Today is the 20th.
What is the date on Tuesday?
24th, Madam Chair.
Yes, thank you. We postpone this matter to Tuesday, the 24th of February 2026 at 9 o'clock to proceed with the evidence of the next witness.
Thank you, Madam Chair.
Thank you. We will adjourn.